Upon notice, my lord, listed motion.
Listed motion, please hand over the slip.
Yesterday I mentioned the matter, my lord, item number 239.
Yes.
Now, my lord, the DM Bakura, my lord, is processed with the, my lord, auction process of the land of the petitioner. Since 2015, my application for extension is pending. There is a direction by the Honorable Court to consider.
239, I allowed yesterday.
No, my lord, your lordship was pleased to give me direction to submit the slip.
Oh, yes, please.
My lord, let it,
You have served notice upon the other side.
Yes. My lord, let it be fixed, my lord, first.
Item number 239 of the monthly list.
Yes.
Yes.
My lord, may I permit, my lord, item 59 combined monthly list, my lord.
Yes.
The difficulty is that, my lord, 21st November, my lord, the assistant engineer issued the notice to the, my lord, petitioner as well as the, my lord, private respondent for, my lord, removing the illegal encroachment and, my lord, illegal construction. My lord, that after, my lord, receiving the notice, my lord, from the local political vendor who himself has introduced as a MLA by creating pressure, and yesterday he, my lord, the petitioner also got the, my lord, received the phone unknown person, my lord, for, my lord, deadly threatening. My lord,
What?
kindly, deadly threatening for withdraw the case. My lord,
Item
kindly
number
fix it, my
59.
lord.
Who is appearing for the other side?
My lord, learned advocate, my lord, Tapan Kumar Mukherjee, learned government pleader also, my lord. I also, my
Private respondent, who is appearing?
my lord, private, Rahul Sinha, my lord. I also, my lord, intimated to them, my lord. And I will also,
Them.
yes, my lord. My lord, kindly, my lord, allow me, my lord.
তোর সময় কিছু আছে? এই দুটো।
24. My lord, if my
Come at 1 p.m. Inform them.
my lord,
Item number 59.
59, my lord.
59 of the monthly list, 1 p.m.
I'm getting.
Please inform the other side.
I will, my lord, immediately.
Private respondent as well as the state. Any other respondents? Yes.
Ma'am, I am permitted to mention on contempt application.
Hand over.
Your Lordship be permitted to mention an application for review for upgradation. It is itself in the 90 item number item. It's not likely to reach today. Your Lordship.
Item number 90.
Yes, my lord.
List.
Yes. And the learned court below is asked for to bring either stay order or in default it will be proceed for argument, Your Lordship. Earlier I have mentioned this matter and incorporate the said order also within my
This is review in connection with civil revision.
easily, Your Lordship.
All right. Come at 1 p.m.
Grateful, Your Lordship.
Yes.
That in item number 1, Lordship came at my instances, my lord.
Yes.
My lord, day before yesterday, my lord, I made this submission regarding, my lord, there is a disposal of the.
Item number list. Call the list.
Oh, my lord.
Item number 1.
My lord.
Item, my lord.
Yes.
My lord, on the last occasion, my lord, when my learned friend made the submissions regarding the disposal of the representations, my lord, and I made a mistake, my lord. I mentioned before your lordship that the project director is the answering respondent, my lord. My lord, instead of project director, my lord, the respondent number 6 is the answering respondent, my lord, the district magistrate.
Yes, Mr. De.
Yes, ma'am.
District magistrate.
Yes, ma'am.
So I'm only clarifying that.
My lord, I am.
Only one.
The district magistrate will consider that. Where is the representation?
Yeah, what's the name?
But no representation to the district magistrate is there.
Yes,
Then I am doing one thing. I'm directing the project director to forward it to the district.
My lord, that is very recently, my lord, there is.
has been added as a party.
No, but in the representation, no representation to the DM.
My lord, if-
Directing the project director to forward it to this representation to the DM.
my lord, but if your lordship, in the very recent, my lord, there is some development in the gazette notification. Here it has been mentioned that any kind of disposal of the representation or removal of encroachment or for past any recent order, my lord, now henceforth from 29th October 2025, DM is the authorized person.
I'm accepting that. I'm only asking you to forward.
My
this
lord,
representation to the DM.
my lord, if your lordship, my lord, if your lordship kindly recorded this notification, only this portion, my lord,
Where is
only,
the
my lord,
notification?
my lord. Ekটু সাহেবকে একটু দিন
Or
না।
I think it will be better if I direct him to submit a representation.
My lord,
Then he will forward-
my lord.
submit a fresh representation to the DM.
করে enter it petition will be treated as representation.
No, no, no.
না না না
That will be decided by the DM.
হ্যাঁ তুমি একটা
What are you suggesting?
রিপ্রেজেন্টেশন ফাইল করতে পারছো না
If you
একটা
want, I can
representation
direct the
করো।
project director to forward it, but it will take time.
হ্যাঁ
Okay.
my lord,
That's
you are
why
not
I can
done.
give you,
Yes, my lord.
Ashwin. This matter was
Liberty to move afresh.
what mistake you have committed, Mr. Bose?
My lord, when I was briefed, I find the relief which is required to be prayed. That is
My lord,
not.
I am appearing for the private respondent.
We have got the state respondent.
We are for KMD lordship.
Mr. Tilak Mitra is against the matter, my lord. He is on his legs, my lord.
I withdraw.
Wants to withdraw. Are you opposing that?
No, 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 my lord.
We are not.
Mr. Basu, do you have the instructions?
Yes, yes.
Mr. Basu is coming for withdrawal. There must be something. So no liberty may be given, my lord.
He's opposing the liberty.
He has a right to oppose because he have to earn fees.
Same goes there, my lord.
I have not heard so.
চিঠিটা কোথায়?
Hey, চিঠি চাই।
To the learned advocate on record.
এই, তোকে তো?
Mr. Basu, learned senior advocate.
Not-
Yes, 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 yes. my lord.
Basu, learned senior
Has to be
advocate.
highlighted.
appears for the petitioner and submits.
But I'm for the petitioner, my lord, the matter was mentioned upon notice yesterday for the reason that the respondents were to file a report, but they have not yet filed pursuant to the last direction. For that reason, your lordship fixed the matter under the heading to be mentioned, so that they can furnish the report.
Yes, Mr. Kaur.
Lord,
The dispute.
dispute is
But this,
very simple. Lord, the dispute is that the petitioner who has challenged a tender, Lord, issuance of a tender, he is himself not qualified. And Lord, he has challenged, that's why, Lord, the question of maintainability was kept open. Unfortunately, Lord, the affidavit, report in the form of affidavit could not be made ready. So I was praying, Lord, a week's time to file the affidavit, Lord, report on affidavit within a week's time. Fix it, Lord, next week, anytime.
Your learned friend said that note a report in the form of an affidavit is not.
In the question, issue of
it's been filed,
maintainability.
and on the last occasion, if your lordship kindly remembers or recollects, lordship, it was submitted by Mr. Shaha that they have already issued in the name of the successful person. If that be so, I have a fresh cause of action.
Interim order has been refused.
That is something else, but they had to file the report pursuant to the order passed by the Honorable Court.
Then, Mr. Dev, there are two things. If you want to file afresh on the.
Or that is
then-
not in the public domain. Let them file the report, lordship. Let us see the report. What
That
is
is, I
the
can,
This
he's
is a-
submitting this.
this
Then
is
it
a-
can, Mr. Dev, otherwise, no use of giving that time extension of time. Then after that, you will. It's up to your decision.
It is his disqualification he has challenged.
Yes.
So, Lord, we will only show.
It's up to you whether to, if you want to withdraw to challenge afresh on the basis of this, it's up to you. Or if you say no, let them file, then I will take a decision. You can take your decision, but that will take a longer time.
I will very humbly submit to your lordship. If your lordship
I
can.
can record that his submission that to whom it has been granted, that I can record.
Yes.
And a copy of document has to be furnished to you.
Oh, I believe he has made him a party. Respond number 7.
But we have not received anything else. We have, my lord, whether it has been awarded to
Mr.
somebody.
Kaur, only
So in that
maybe
case, lordship,
the
kindly direct him.
subsequent facts he can have.
No,
he has
of
to
course.
take.
That's why I'm saying I'm prepared to
But
discuss.
you want, Mr.
Or
Dev.
in that case, lordship, let them file the report in the form of affidavit as directed by the Honorable Court. Lordship, kindly fix on any day. Let it appear under the heading to be mentioned, so that they can furnish it, and thereafter your lordship kindly pass the necessary order.
For furnishing, why to be mentioned,
No,
Mr. Kaur?
very
I
well.
fix- Mr. They are fixing a time limit within that
Very
peremptory.
But
they have to
and
do.
I make it clear, Lord, if we file the report, then Lord, I will press Lord the maintainability point first.
Yes, yes.
Because
That's, I think you have said that.
yes, it is kept open. Kept open.
It's
Kept open.
kept open. So no further
Correct.
observation is necessary.
না না কিছু লাগবে না
You are for the respondent numbers 3 to 5.
3, 4, and 5. I'm the
You are the answering respondent.
yes, Lord. I'm the tender issuing authority.
I appear on behalf of the state, my lord, late
Yes.
by learned it.
Ashwin. Have you filed a direction to file report upon whom?
Both,
All.
both respondent and state both.
You don't want to file a report, or you do it within the extended time.
It really doesn't have anything to.
They want to, I'm extending.
Right.
Mr. Kaur Lanet Next.
Let them serve in the meantime, Your Lordship.
Sir, I have said upon serving an advance copy of the same.
I'm grateful to Your Lordship.
Yes. Correction.
Some typographical mistake.
Oh, numberta. It has been pointed out that there is a typographical error in the year of the
Correction.
correction, the year of the petition was
As it
wrong.
is.
Yes, Mr. Sengupta, you are appearing in the earlier matter.
Item number 4 only.
Item number 4 Mr. Sengupta নামটা record করুন। Yes.
হ্যাঁ দাদা আপনি তো আছেন জানেন।
5 May an accommodation for today.
This writ petition is not
Not
maintainable
maintainable.
before this honorable court, my lord. They have challenged the vesting order as well as the mutations.
This
It is the domain of the learned tribunal.
This is maintainable, my lord.
Satisfy me, for that it was that time was
We have
granted.
filed our, my lord, report. and we have
question
taken
of-
our-
The question of whether,
On side,
Well-
let them say, then I'll say.
my lord, I tell your lordship, my lord,
Why are you getting agitated? You are a
Let them say.
very short point. A property belong to Bond and Standard Company, which is, my lord, retained under section 6(3) of the West Bengal Estate Acquisition Act. In 1976, my lord, there is a nationalization of Bond and Standard Company, and it was a nationalized company. Subsequently, this property was transferred in favor of Indian Railway. Now, it is the contention of the petitioner that they purchased the property in the year of 1973. Accordingly, the 76 acquisition, my lord, this is outside the purview of 73 acquisition. Now, they applied for mutation. The mutation was turned down on the ground that this is a there is a
mutation before the
BLRO. Now, my lord, the question is the mutation was turned down on the ground. There are twofold ground. Number
Right, so on certain grounds the mutation was rejected.
rejected. Now, my lord, what happened?
They are challenging that order.
No, there, my lord, in this particular writ petition, there are twofold prayer, my lord. Number one, the declaration that this property, my lord, this property outside the purview of 76 acquisition, which is a disputed question of fact because the sale deed, which is, my lord, they have annexed of 1973. We are pointing out there are so many fallacies that this was transferred by way of power of attorney. The Kishan Lal Agarwal and Kanhaiya Lal Agarwal both are different. They are saying these are identical. So this is a disputed question of fact. Now, number two is whether the property which is already, my lord, vested to the state and, my lord, there is a retention order under section 6(3) that can be transferred in favor of a private individual by the bond standard or not. This is number two. Number three, the mutation which was turned down by the BL and LRO, whether that can be considered before your lordship in, my lord, in 226 application.
Prayer, my lord, lordship, can you see the prayer?
Prayer A and prayer B, my lord. Prayer A, so far as the prayer A is concerned, it is our contention. This is a disputed question of fact. And prayer B is concerned, the 6(3) as well as, my lord, mutation.
How the vesting order can be challenged in a writ petition?
But they have said to their heart's content, now let me see.
We have not yet placed any judgment
No, no,
as it.
No. We are on extension of interim order. My lord said why this writ petition is at all maintainable or not. Well, today, if I satisfy my lord that the writ petition is maintainable, my lord will extend the interim order and hear it the matter threadbare because hearing is required here. Now, my lord, what has happened? Short facts. This property belonged to a company called Bond Standard and Company. The petitioner's predecessor interest purchased it on the year 1973. 1973 December, we purchased in sometime in June. 1973 December, the Acquisition Act comes. Central government acquires Bond Standard and another company. Now, in that acquisition proceeding, it is stated that any bona fide sale 6 months prior to the acquisition is valid. Now, this company becomes nationalized by the Nationalization Act of 1976 from 1/1/75. Now, the entire property which is of one standard becomes a central government property by virtue of the such acquisition of the company by the central government. Now, we are having this property since 1973. Now, we go for mutation because we want to mortgage the property or something. We want to mortgage the property. The BLRO says, since this is the central government property, I cannot, the property is in the name of the central government. I have given the portrait, it says that it is Sarkar Bahadur. So, my lord, West Bengal, my lord, Land Reforms Act will not be applicable.
Why? Why Land Reforms Act will not be applicable?
Government, it's a central government property.
Whatever may be.
Now, my lord, what we
Central
are,
government property is exempted from Land Reforms Act. Please show me. Please show me that it's exempted from Land Reforms Act. Under which provision the central government property is exempted from Land Reforms Act? The only exception is section 1, subsection 2. Do you fall within that?
No.
Then what's the only exception? Where do you find that it is excluded from the Land Reforms Act? And right, wrong, I'm not going into the correctness of the order prayer for.
No.
So even if it is, I accept that it has been wrongly rejected. You approach the tribunal, that's the authority.
No,
Because this is a specified act. You approach there, challenge this, that this could not have been, it's a central government property, it could not have been vested.
No, I say it is not even a central government property.
All right, so vesting, it should have been done in
There is
your
no
name.
vesting. I say when I purchase.
Then why have you made this prayer? Withdraw this prayer, prayer B. Prayer B says so. Quashing, recalling of the order of vesting. Withdraw this prayer.
Prayer C, mutation.
Withdraw this prayer. Withdraw prayer C. I will take up this.
Nothing remains.
Prayer B.
Let me take instructions.
So these are the
Prayer
prayers.
D.
These are issues which can go be gone into by the
Why we
tribunal.
are invoke the writ jurisdiction is because, my lord, the Central Act is involved here. Central Act of nationalization of the
Two
land.
things. If it is an you have approached an authority under the Land Reforms Act.
Yes.
You have approached for recording your name.
Yes.
So you have subjected to the jurisdiction of the block land and land reforms officer.
No, on the ground that the property belongs to me.
Yes, for whatever reason. So you want it to be mutated. Show me your application. You wanted the property to be mutated in your name in the revenue records. So you have approached, I think, under section 50 of the West Bengal Land Reforms Act.
Para 11
Or for correction 51, 52, anywhere the other sections of the Land Reforms Act. If you have done so, you have applied certain provisions of the Land Reforms Act. If an order has been passed on those provisions, and Land Reforms Act being a specified act, in view of the West Bengal Land Reforms and Tenancy Tribunal Act, the High Court's jurisdiction.
That is what.
Then
kindly takes then, my lord, page 44.
Yes.
Kindly takes page 44.
Of the writ petition.
Of the writ petition.
Yes.
Yes. That has to be challenged.
You are challenging this.
We are not challenging this.
Then
we are saying.
Show me your application, this subject of mutation. Show me your application.
The application has not been.
This is the subject matter. What are you saying?
It has to be challenged either before the civil court or before the tribunal.
Once you can say that if I have the title. So if you want declaration of your title, you have to go before the civil court. If you say no, there is no dispute with regard to the title. I have the title, but certain other person's name has been wrongly recorded in the record of rights. I want that to be corrected. You have approached the revenue authorities. Revenue authorities rightly, there may be two things, either rejecting or inaction. Both are subject matters of challenge before the tribunal.
What do they say? Since that, kindly sees 3. Kindly sees 3.
Yes.
as the land belongs to the central government under 6.3 of WB Act is no 6.3 of WB Act is not applicable as the central government is not a right under the state.
So this is a finding on fact. Wrong may be wrong finding. Challenge
Very
that
wrong
before the
finding. Yes,
appropriate
sir.
forum.
Yes.
I'm not saying this is correct. I'm not going into the correctness of that.
Yes.
No, if central
If I-
government, where do I approach? Because I have to
Just
now
before the
say,
tribunal.
So, please see the West Bengal Land Reforms and Tenancy Tribunal Act. Please see this. After this, we're aware of those line of decisions, L. Chandrakumar, starting from L. Chandrakumar and other decisions. And the
Moreover,
High
my
Court's
lord, our High
jurisdiction,
Court, my lord,
more
notified.
so, single bench
Yes.
do not have jurisdiction. Even I accept that an alternative remedy, if I go to that extent, that even existence of an alternative remedy is not a bar. Even then, single bench cannot entertain.
Even my lord, our High Court, my lord, notified in the my lord list by the registrar general, the no application cannot be entertained. May I reading? In view of the provisions of the West Bengal Land Reforms and Tenancy Tribunal Act
You have a copy of the act.
1997, and in view of the order
Please give
passed by the
copy of the act.
Supreme
You have a
Court.
copy of the act.
My lord, के दिन एक दिन
Specified act.
My lord,
Please see section 6, 7, and 8.
2R.
दाग दो আছে।
2 are specified act.
Specified act.
Now, please kindly come to section 6, 7, and 8.
ওটা দেখি my lord কে দিন। ওটাই আসবে না। ওটাই আসবে।
You will be covered under A. 6.1a, any order made by an authority under a specified act. BLO is an authority under the specified act. And exclusion of jurisdiction, please turn over to section 7.
no, that is there.
And 8 is exclusion of the jurisdiction. Only division bench can exercise jurisdiction under 226, 227 against an order passed by the tribunal.
That is there, man. But my lord, this order says, my lord, this order, what does this order say? That since central government is not a right,
I cannot go into the correctness of that. You have a remedy under the act.
but then LRTT will say, I do not have jurisdiction.
Why? Why are you preempting that? If LRTT says so, you have the division bench here. Because that's the procedure.
But LRTT will say, I do not have jurisdiction since the
Why
central
How do you
government is
say
not a
so?
right.
How do you say so that the LRTT will also say that?
But this order is palpably clear that central government is not a right.
So, Lahiri, please approach the tribunal. And if you want to waive your or not press prayer B and C, then I will.
Nothing
Let me take
remains.
instructions and come back. If I have to progress, I won't press.
My lord, instead of, my lord, kindly fix the matter in the next week for hearing. Yeah, you cover it on the proper instruction.
If I can,
Then it has to be in January.
January. But for that period, kindly.
No, my lord, we are opposed.
Extension. No extension, because till now I'm not satisfied with the
I
maintenance.
understand, my lord.
No.
Railways will take over the land, my lord.
My lord, the crores of rupees of railway project remain stalled.
Then you can approach the tribunal because till now I'm not satisfied with the maintenance of the writ petition. If I'm not satisfied at the time of extension, also this point can be taken. And for the purpose of passing an interim order, maintenance is to be decided.
I understand.
You know these propositions of law.
On that
And when this issue has been raised and considered, and on the last occasion, this point on this ground it was adjourned. Now it cannot be.
Can it be fixed on 6th? Then
6th of January. The learned advocate appearing for Two extension and two means same AD.
To be mentioned. Extension list.
Yes.
Item number 6. But Mr. Devajit is appearing. He's coming, my lord.
Yes, start. Yes.
He's coming.
Then.
I am for the private respondent led by Mr. Patkar.
I beg to pay on behalf of the story.
May it please your lordship.
Yes.
My lord, before your lordship opens the brief, may I just tell your lordship a very brief facts? My
You
lord.
want me to open the brief? What do you want?
I am ready, my lord.
Yes.
It is not that I am trying to take time. Now, my lord, a order of a past and
Order of a?
order of an authority passed under Highways Act 1964, confirming appeal is under challenge before your lordship. Now, my lord, I
Challenging 10-4 order.
my 10-4 order. Now, my lord, I am a
You
local
are
body.
found to be an encroacher.
It is an allegation.
Found 10-4, not an allegation stage. It's a
My
determination.
lord, I say this 10-4 precisely, my lord, West Bengal Highways Act apropos is not applicable. Now, my lord, I would take, my lord, two law points, my lord, for my lord's kind consideration and adjudication. Before that, may I just say this? Who am I? My lord, I am a body corporate under the West Bengal Municipal Act. I am a local body. My lord, a municipality is also a government body. That is also been decided by the Honorable Supreme Court. Now, my lord, I would take 2 points on this aspect. So far as Highways Act is concerned, the saving clause, section 26, my lord, gives me an immunity, my lord, to make any construction. My lord, I have that, my lord, West Bengal Highways.
Operate. No, I have a copy.
For your lordship.
Yes.
Now, my lord, straightway, if your lordship, my lord, takes up section 26, savings clause,
Yes.
nothing in this act shall affect A, the rights of any local authority. Now, my lord, local authority is defined under the Bengal General Clauses Act, section 2,
yes,
subsection 31. To make any excavation for the purpose of laying, making, altering, repairing, or renewing any sware, drain, water course, or other work. Now, my lord, I will stress on also on the other work. This work, my lord, your lordship would be pleased to find, my lord, in the 7th schedule, second list, my lord, which work defined. My lord, these are constructions, my lord, civil construction, engineering constructions. The same, my lord, the definition of work would also, my lord, place in, my lord, Oxford Shorter Dictionary and, my lord, dictionaries and what is the meaning of a work. Now, my lord, this would be my one point of argument that I am immune for any constructions. So far as, my lord, this, my lord, I really, my lord, want your lordship to adjudicate. My lord, so far as the, my lord, the proposition is concerned, with my humble legal acumen that I would try to develop, supported by some precedents, my lord, with the different meaning of a work, my lord, how the constitution has, my lord, regarded this work, my lord. Along with that, my second limb of submission is, my lord, so far the Government Buildings Act 1999. There, my lord, I might be in some better positions because I have a two judgment also on the exactly on this point. But I really want first point to be decided because I do not find any judgment on this particular section 26. There are many judgment on Highways Act on section 10, but not on 26. This is my request, my lord, so can you decide whether this is at all, my lord, to be done. Now, my second point of is on or alternative or in addition. So far, the Government Buildings Act 1899. Section 3 and subsection 4, it says, my lord, any constructions made by a government body on a government land, my lord, Highways Act is not applicable, I am immune. Now, my lord, there are also two judgments. Lordship is a famous judgment, is as our own High Court. Your lordship is aware of the Honorable Division Bench by, my lord, by Justice Senior Bhattacharya, my lord, passed this order,
which was, we even went to the Supreme Court, only a question of heritage, whether this High Court could be given heritage or not. There are another matter, my lord, by Justice, a coordinate bench, Justice Chondo. Justice Chondo also appeared in the division bench. Then, my lord, Justice Chondo also passed a judgment on a same point, where, my lord, constructions made on a defense land by a defense personnel, my lord, was under challenge, since, my lord, a 401 notice was issued by the KMC authority. And, my lord, Justice Chondo held that KMC has no power, no authority. Now, my lord, only one point that also, my lord, may ask to your lordship, my lord, because section 3 says that there has to be a notice of intimation of constructions. Now, my lord, to be given to whom?
This act.
Under Government Buildings Act, 1899. There, my lord, Justice Senior Bhattacharya, my lord, was pleased to hold that though there was no consequence that for not
Show me the decision.
My lord. Now, may I just take 1 minute more, my lord? Because there are two things, my lord, that here also I say that notice doesn't require, because notice is to be given to the municipal body. Here I am myself the municipal body. It is within my presence, within my municipal area. So, but here the purpose of notice, it is merely a formality.
So, Mr. Basu, so municipality can encroach upon the highway.
No, I do not say that.
Can also make a construction on the highway itself.
No.
Why?
No. Here
Because this submission is to be accepted. So under this, any work, so in the main highway, it can be obstructed. Construction can be put in.
No, my lord. What I most respectfully submit, my lord. Here, my lord, this is a question of construction.
The decisions.
My lord. My lord, may I just first, my lord, indicate so far as West Bengal highways at, or my lord, I would.
That choice is left with you.
Very
You can choose in which way you will argue.
Very, very, very.
Permission. So it is understood there is no permission, because last occasion, my lord, it is understood there is no permission, because earlier occasion is a specific.
So he says that he does not require any permission.
No, that is something else. It is something else, because the earlier occasion, the Lord Advocate representative Alkali considers the earlier order passed by your lordship.
There is a proposal for interdepartmental.
Yes, yes. Mr. Basu, your learned friend submitted
Yes,
that.
my lord, that is what I say, my lord.
Please make submissions on that first.
My lord.
Whether there is any permission or not.
No, my lord. Possibly, my lord, what I say, my lord, I tried to, my lord, explain that. I did not say I do not require any permission. But I say this highways
Have
that.
you got any permission?
Yes, yes. I have
Please
got
show me.
permission.
Please show me the
My-
permission first. Please give copies to your other side.
It is saying there is no permission.
My lord, the interdepartmental proposal is there.
Oh,
And these documents are not in the part of the proceeding because it is of
let him
24.
give you a copy.
My
He has given you a copy.
I have given that.
Oh, he has a copy.
Please give a copy to the other side.
Other side.
My lord, kindly, my lord, see, this is a type, my lord, this is a handwritten copy. Kindly see, my lord, the type copy, the next page.
No, any further document after this? This is a
Yes.
proposal.
No,
After
no, no.
this-
No, my lord, kindly see, my lord. In reference to your above mentioned letter and in considering the public utility services to be rendered by your authority and in anticipation of the executive engineer Tomluk Highway Division approval, you may start the construction work. So I was permitted to start the construction work also.
Yes.
Of office complex of your authority such and such under Mouja Durga Chowk. Of your authority.
Construction work of
office complex of your authority.
So office complex permission was given.
My lord. Now, my lord, here.
This falls within the expression other works. As in 26.
Now, my lord, so far as my lord, my instruction is, my lord, we constructed.
Because you are trying to make submissions harping on the expression other works
Lordship.
used in 26.
Lordship.
So it appears from the documents which you have placed, you are permitted to make a construction work of office complex. Office complex comes within the expression of other works, as in the schedule of the constitution.
Lordship.
Yes.
Now, my lord, kindly turn to the next page.
Yes.
Proposal for transfer.
Plot number same as.
Yes.
My lord, the earlier letter was of
Next page
88.
is the type copy. Oh, the after that.
After that. My lord, first one is a handwritten, second one is a type copy of the handwritten copy. This was of 1988. Then, my lord, kindly see, my lord, on referring that letter, an 89 letter was written. Proposal for transfer of such and such under Moucha for construction of office market complex. Kindly see, my lord, office market complex and rickshaw stand. In response to his letter under reference, this is to inform you that the land in question may be handed over to Holdia Notified Area Authority after fulfillment of all the formalities for the purpose of as proposed. Number the I was given permission to construct already in 1988 later. Then, my lord, subsequently, in Holdia municipality issued a letter. Kindly turn to the next page. Lordship was found, my lord, 23rd August. Regarding fulfillment of formalities of such and such of handing over under Mouja, under such and such for construction of office market complex and rickshaw stand. The undersigned would like to bring your kind notice that in a very past, the then Holdia Notified Area Authority, currently Holdia Municipality, received letters from your authority with a memo number 88, such and such in the year 88 and 89 from Assistant Engineer Holdia Division and Executive Engineer such and such regarding transfer of land such and such and under Mouja to the then HNAA, presently Holdia Municipality, for construction of office market complex and rickshaw stand. The copies are annexed herewith for your kind perusal. In view of the current public interest in the vicinity, this becomes an utmost of necessity henceforth. The authority of Holdia Municipality is interested to complete the remaining formalities regarding this matter. Hence, your kind necessary guidance regarding this matter
What
will
is the
be highlighted.
disputed plot where you have constructed?
My lord, this plot, my lord, relates to the government of West Bengal.
What is the plot number?
1452.
1452.
1452.
Formalities completed for inter-department.
Formality complete.
Please see the last document. Last bunch of documents, last document.
Yes.
Completed.
এটা অন্য। So far as the letter of 17/9/2024, as would appear, my lord, born from the records, that here, my lord, only departmental transfer of land is under process. So, my lord, here, may I say this? May I just the permission for construction was given.
Yes.
Permission for construction was given.
So land has not yet been transferred in your name.
Land has not yet been transferred. This is a departmental transfer. So far, my lord, from the PWD department or from the development
Your
board.
proposal was for transfer in your name and for construction. Till date, there is no document to show that it has been transferred in your name.
But
So
here,
at some point of time, you are allowed to make construction. So this is the factual.
my lord, I was allowed to make construction.
Yes.
I had
allowed to make a construction. You made a proposal for transfer, but the fact remains that transfer process has not been completed.
Transfer process has not
because
been
you
completed.
wanted that this property to be transferred in your name.
Very well. Now, my lord,
That has not been done till date.
my lord, now, my lord, here is two distinct parts, my lord. So far as my construction is under challenge, Lordship may kindly appreciate. My transfer is not under challenge. The Highways Authority's order also, my lord, concerned about the construction.
Please show me the highway authority.
My Highways Authority order to সাপ্লিমেন্টারি আমার ফাইলটা ঘাটবেন না, নিজের ফাইলটা বার করুন। জজ সাহেবের কাছে আমি বকুনি খাবো তো আপনি খাবেন না। Well, he was trying to take away my pay. I said, আমাকে বকুনি খাওয়াবে না।
Yes.
Kindly see, my lord,
Yes, which page is the order under 10.4?
Yes, kindly comes to my lord, page 52. 52 of my lord's brief.
Yes.
Lordship has seen, my lord, this is an appeal order 10-4. My lord, prior to that, kindly takes a 47. That was SDO's order. I think, my lord, that would be much more convenience, my lord. Lordship has found page 47.
47.
My lord. না 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 আমার আপনার মতো সে ক্ষমতা নেই মানে the petitioner and de facto complainant. Now, my lord, kindly also marks, my lord, here for a moment. The department who owns the land, for the time being, they did not make any complaint. It was a private party. Petitioner and de facto complainant were present. Opposite party was absent on call. Hence,
The reason because Mr. Basu, the authorities are keeping their eyes closed. Only when some private party comes,
my lord,
they wake up.
My lord, lordship may also appreciate.
They wake up.
No,
So
lordship.
they know everything. It's not a fact that they do not know anything.
Legal
They know
construction,
everything.
the Supreme Court has enlarged
They
the scope.
are sleeping
Why?
with their eyes
No,
closed.
my lord, I would also develop, my lord. Here, my lord, the authority itself.
That is the reason. That's
No,
the reason why they did not
my
make a
lord,
take
my lord,
any
my lord,
steps.
this is one side of a coin. The other side of a coin, my lord, the government, the state itself in their affidavit before my lord admitted that there are protection under the Government Buildings Act. They themselves have admitted, if your lordship, I will show it from. Now, my lord, kindly see.
Then let them recall this order.
No, they did not pass this order. Passed by the Highways Authority. Passed by the Highways Authority. I will show from their affidavit. The case record is taken up to dispose of the matter. Lordship has found, my lord, second
Yes, yes,
paragraph.
yes.
It appears that the assistant engineer Holdia Highway Division, such and such, Rural Department, Chaitanyapur, Purva Medicine, issued a notice such and such. The chairman Holdia Municipality, with a direction to remove the unauthorized encroachment from the public land, but the encroacher did not comply the order of the authority. Peruse all document, including the report of BLRO Sutahata. Considering all the factors and from the hearing, it appears to the undersigned that there is an unauthorized encroachment on plot number such and such, belongs to development and classified as non-injury, etc., such and such, and in the front of Rayat plot number such and such. Hence, in terms of section 10(3) of 1964 Act, I, SDO Holdia, do hereby authorize the assistant engineer Holdia Highway Subdivision, PWD Road Department such and such to recover possession and remove encroachment from plot number such and such. Reference, High Court order number such and such. The officer in charge, Sutahata Police Station, will render necessary and lawful assistance to such and such. Now, my lords, kindly see the appeal court in appeal order.
Page 53.
Page 52 at 53.
Yes, yes.
As per report of the BLRO Sutahat, it appears that the plot number such and such are Rayati plot and plot number such as non-injury measuring 59
On
decimal.
facts, it was found there's an encroachment.
It was.
You do not dispute that factual finding.
I don't dispute. My lord, I do not dispute that factual finding to the extent, my lord, I say I did not encroach because I was permitted to construct. My lord, lordship.
So now it's the interpretation of the statute.
My lord, lordship may kindly see. Now, my lord, there are two distinct parts, my lord. There's, as I, my lord, lordship may kindly appreciate, my lord, and kindly correct me if I am wrong. That encroachment and constructions. Now, if I was permitted to construct, then obviously, my lord, I have to be there on the land. If I do not be there on the land, I cannot construct. Now, if my construction was permitted, my lord, there could not be any case of encroachment. The only question that may remain, my lord, which may not be an issue for your lordships to consider with the deepest of respect, that whether the transfer of land is complete or not. Now, my lord, so far as the two acts, my lord, Highways Act and the Government Buildings Act, my lord, may not require the authority who shall construct also to get land on his own name. Of course, my lord, permission is necessary. Unless, my lord, it is his own land. As for example, my lord, I was citing, my lord, Justice Chandra's judgment where, my lord, defense was constructing on defense own land. So 401 notice was under consideration. The coordinate bench held that no such permission was required. KMC cannot transgress into different such and such because those are protected. Now, before your lordship looks into the other aspect, kindly takes up the affidavit in opposition filed by the state, the department itself.
Affidavit in opposition.
My lord. Oh, Dada. Lordship has found, my lord. Respondent number 4.
Respondent number 4.
Assistant Engineer, Holdia Subdivision.
Yes, yes.
Who initially passed this order?
Yes.
Lordship has found. Kindly turns to page 5. See the bottom. Subpara K. It is submitted. Lordship seen, my lord, that as per provision of Government Building Act 1899, there is an exemption to the government authorities for construction of any building as per provision of section 3 of the said act. And only layout per plan is to be submitted to the concerned municipality or panchayat. That is what I, my lord, more respectfully submitted. That section 3, two things. Just the coordinate bench said that if it is something for a national or
Do you
security.
have a copy of the Government Building Act 1899?
My lord, that I, my lord, kindly apology, my lord, that I have, my lord,
My lord,
missed
whether
it.
my lord
But
is
the
exercising
judgment.
power of review.
Started that you will be citing these now.
No, no,
Just say you don't have the copy of
No,
this
no,
act.
no, may I say this? My lord, the judgment that I
Said
would.
that you will be arguing on those this Government Building Act.
No, my lord, may I say this? The judgment that I would refer, my lord, itself quoted the entire act. Lord.
Give me that.
My lord is seeking
My lord, I do not embarrass your
division bench
lordship.
judgment. My lord is sitting in review to division bench judgment. I put this
My
question.
lord, I would also answer. I would also answer.
Yes.
Division bench.
Yes, page
But I would
45.
also answer.
Where is the division
My
bench?
lord,
Page 45.
my lord, may I also indicate
45.
these points were never, my lord, neither raised nor decided.
Page 45.
I would also answer to that.
Page 45 of the writ petition.
Yes, yes.
Division bench, my lord, only considered. My lord, may kindly read the order
It
first.
starts on page 41. Can you turn to page 45?
So this division bench order was at what stage?
After passing of the challenging the order, 2019 order. If you logical previous order, page 30.
Stage 10-3,
10,
10-1, what
10-4.
stage? 10?
10, 10-1. 10-1.
10-1.
Yes.
So then what was the direction passed by the division bench?
Your lordship find it's affirmed the honorable single bench order where that is at page 40.
Yes.
Since encroachment has been made, my lord will find the penalty portion.
May I assist your lordship, my lord?
Page-
Even on this point, kindly comes to page 45, the last two paragraphs.
Yes.
Court division bench said we only directed to initiate proceedings. Let the proceedings be continued. These points, which I would urge now, my lord, it was never considered, neither decided. So there is no question of res judicata. Your lordship would definitely not transgress or review, my lord, the order passed by division bench. And this again, my lord, after my lord, by having the interim order from this honorable court, my lord, on filing the writ petition, they again moved before the division bench, showing this order. Division bench said, no, very well, whatever the points of law that the honorable judge, my lord, sitting singly would decide. Now here, my lord, the court considered it admitted that the municipal authority had made construction on the land of PWD without permission of the PWD. The said illegal construction is restricting such and such. Honorable single judge, by considering the report of special officer, had only directed the authority to initiate proceeding under section 10, what she was found, my lord, of the Highways Act for removal of the illegal encroachment of the property in question. The PWD had acted up.
The thing remains,
My lord.
issue of encroachment decided. Only these proceedings were directed to be initiated. That means notice for removal. As simple as that. Nothing further was left after this division bench. Clear finding.
Millard, the findings was not on the basis. Millard, there is
what
also
basis, not basis, I cannot go. Only one paragraph is troubling. It is admitted that the municipal authority had made construction over the PWD land without permission of the PWD. The said illegal construction is restraining such and such. The Honorable Single Judge, by considering the report of the special officer, has only directed the authority to initiate proceeding under section 10 for removal of the impugned encroachment over the property in question. So there was no necessity to decide on the issue of encroachment because admittedly this construction was on encroachment, was found by the division bench. After that, it's a mere formality of those procedures 10-1, 10-2, 10-4.
No, Millard, may I say this? May I, Millard, obviously since Millard, it has
Encroachment issue has been finalized, Mr. Bose. You have not I cannot sit in appeal over the division bench.
no,
I
Millard,
cannot go, no, this was not considered, that was not considered.
no, Millard, I would
Ultimately, the finding observation has ultimately, because you were present there, you did not raise these points. Constructive res judicata.
no, Millard, here, Millard, something findings.
It's a principle of constructive res judicata.
Same proceedings in different stages.
And you are a party to that proceedings. So constructive res judicata will apply. These points were available to you, not raised. Subsequent proceedings you cannot raise.
No, Millard, there may be two parts, Millard. I've understood, Millard. I will try to, Millard, find out the on these issues, Millard, and come back to answer this. Other than this, Millard, because this is something Millard has pointed out to your lordship, I'm grateful. But here, Millard, something, Millard, which are documents which are available to me, Millard, I may not, Millard, or I was not able to produce at that point of time.
Take steps then. So
I
did not advise you.
Of course,
So
of course.
If you say that I had some documents, it's up to you to work out your remedies. But now I cannot go to that.
So far the other parts are concerned. So far the other parts
Mr.
are
Basu, if you want some time, I can give you some time to get yourself ready.
very
But
well.
after this, nothing remains.
No, Millard, and of course, Millard, I need on this point, Millard, to answer. But here, Millard, the other parts it. So far, this, Millard, the protection
no
under the
hearing, Mr. Basu, if you want.
No.
then
I
if you are
shall
ready-
only indicate for 10 seconds that other parts, Millard, which I still, Millard, can argue. I would also think, Millard, that even after this finding, the Protection of Government Buildings Act or Millard West Bengal Highways Act
are available at that stage. These points were available, all points were available at that stage. Jurisdiction, neither. This is the first time you are raising this issue.
These you are not before the appellate authority.
None of the forums you have raised this. Even before the authorities, you have not raised this. This is for the first time here because I am only concerned whether the
Procedure adopted is correct or
yes, performing its duties under 10-1 to 10-4.
not the
Yes.
decision ultimately. Lordship will only see the procedure.
Yes, only procedures. So you have not raised anything, and more so when this issue of encroachment has already been decided by the division bench. These points were available to you.
But I was only
Yes, that-
thinking, Millard, since a question of law, Millard, since it's a pure question of law, Millard, which was, Millard, if anyway, Millard, I'll try to find it that even after this.
After some argument, Mr. Basu Authorized by the division bench.
Malad, that your lordship, Malad,
ওটা রেখে দিন, ওটা রেখে দিন। আচ্ছা, ওইটা লিখে দিন, একটা লাইন লিখে দিন।
of this fact.
Since 2022.
Malad, from filing of the writ petition, when they move. At least, Malad, this much of
From 2022, it is continuing. At no point of time you took this point. It's continuing. It has to be continued.
No, I do not say. Malad. At least, Malad, till Malad.
Today, Malad,
For a
it
limited-
appears with the court that yes, because earlier occasion just
Mr. Rai, so long
till
it's continuing.
18th.
ও আচ্ছা, ঠিক আছে, আমিও মনে রাখবো। ভাইসে ভার্সা হবে।
ঠিক আছে, তাহলে যদি এন্ট্রি অর্ডার দিই তাহলে মানে order.
Yes.
It will be taken up. Yes.
I'm extremely grateful.
Huh? How long you will take, Mr. Basu?
Maximum 30 minutes.
30 minutes, Mr. Rai.
Malad,
Acha, forward us.
I will take only 10 minutes.
All right. Under the heading forward us.
30 বলে 2 ঘন্টা নেবে।
Yes, call the next matter.
Number 7, I am for the petitioner, but we are praying for extension of the period of lease. My learned friend Lord has produced a judgment. On the last occasion, he said he has handed over yesterday, my Lord. A judgment, he says, covers the field. Kindly give us some time.
Mr. Basu was here in
Mr.
this
Basu
matter.
was.
Where has he left?
He was here, my Lord. A matter of he was also going to make the same prayer.
মানে
Kindly give us some
paragraph
time.
26
Let
and
me see this.
it is just the view of my lord.
Let me see this.
Paragraph 26 and 28. Damage. 20.
More or less in the same line. Mr.
No,
Rai.
in that case, my Lord, it was a case of non-payment of a part of the installment. This is not a similar case.
Maybe the grounds. There are twofold.
But in that particular
yes.
case, there is a
Remedy in
restriction
damages.
by the
There are
state
two
government.
things. One is it's a full-fledged commercial contract.
Commercial and another
Because
remedy.
commercial contract. Now, whether in a writ petition.
Under a rule, my Lord, all the petitions the Lordship is entertaining is not under the rules.
And 28 is a remedy lies before the civil court.
Lease under the rule. All the rules, government rules are applicable to the contract, my Lord. In this particular case, there was no
20.
restriction order. from
According
this
to you, it's a
government.
statutory contract.
Statutory contract. Kindly see, issued under the rule, under the form application has to be made. We have to follow.
Paragraph 29.
28
remedy at best lies in the claim for damages.
damages.
In
That
the
is
facts
the
of
view
that
of my
case,
lord.
In the facts of that
29
case,
is there is no scope to extend because in view of the change of policy.
because of the fact, no, in that case, what happened? The payment was not made. The installments were not made. This is a concluded contract.
Those are the
There it was
reasons.
not a concluded contract.
Mr. Banerjee, those are the reasons. Now, the question is to whom to direct? State to direct. In view of the change of policy, they cannot extend.
No, lease deed was entered into. It contained a clause
Yes,
that
now,
in case of
Mr. Banerjee,
force majeure or akin clauses, there can be an
damages,
extension.
damages is there. Mr.
The clause is not damages. Clause says extension.
Clause says
Now,
extension.
in the facts of this case, court held that no, there no circumstances exist. It was a case of non-payment of the balance amount. So
In
facts
that-
are different. I'll try to
In
satisfy your
that
lordship.
case also the government has restrained him. Here there is no question of
here
restraint.
suspension.
Suspension. That
Because
was
of
challenged.
because of
That-
non-payment.
That was
within the period.
the case of the prisoner is a more worst.
No, these are much better case. I'll argue.
No,
Lord.
no.
Maybe factually you are on a better footing than that.
There was a restraint
Question
order by the
is,
government.
whether now
Here,
the
my lord,
extension of lease deed.
Admittedly, my lord, admittedly, my lord,
to damages, but in the case of the writ petitioner, there is no restriction order
The restriction order.
because of local
This appeal was against an order directing extension.
no
by
this
the
is the
court.
order against rejection. Rejection order was upheld.
court did not extend. Against that, they have gone.
Statute provides for extension. Where is that?
Lease deed, there's a clause, my lord.
Show me.
Kindly allow me to come back in the next week, my lord. Mr. Basu wants to argue, my lord.
The learned advocate appeal.
Those circumstances. If I can satisfy the circumstances,
Question
exist.
is, Mr. Banerjee, I put it to you, please come ready with regard to that. Even if that is permissible, whether a mandamus can be issued.
Issued.
Directing, yes, please extend, you are obliged to accept this. It's the state's right, Mr. Banerjee. State may have a right to do something. State may also choose not to exercise that power.
If that is arbitrary,
state-
but I can come to your lordship.
There are decisions, Mr. Banerjee, on this. If some power is vested with the state, it's the state's authority. But the state chooses in such circumstances not to exercise that power. Whether the writ can be issued directing, yes, please exercise that power in my favor. Subject to correction, mandamus cannot be issued.
If the non exercise is supported by reasons, they can.
Please consider those line of decisions. If the state has some power which it can exercise, the person has a right to claim sick mandamus, directing the state, please exercise that right. Unless you show that there is some legal right in you and failure on the part of.
And authority has passed the order, there, it is under challenge. That
Please consider
The
those.
interim order is till tomorrow, kindly extend it till not sometime after Tuesday.
on Tuesday, till Tuesday.
Consider
Yeah, I'm for the petition.
yes.
For the construction of Milord embankment in Balidanga Mouja, Nodia. Milord, my property under plot number 308 and 309 is being utilized. Milord, similar.
For public benefit, Mr. Mukherjee.
Milord, I am the poor cultivator. Milord,
Public
my
benefit,
Milord,
larger public interest.
my land goes, Milord. Milord, my entitlement under the law. That Milord, and the very interestingly, similarly circumstances, Milord, the Milord, other land loser approach this honorable court. This honorable court in
Yes,
two,
Mr. Bandyopadhyay, is it a
Let
finding?
him finish, Milord.
two
Let him finish.
in the two Milord matters, Milord, two different matters, Milord, where the state has taken a stand that yes, since this land is being utilized, so irrigation department will come and directly purchase, Milord,
Direct
direct
purchase
purchase
policy.
policy. Milord, before Justice Munshi, as his lordship then was, and also before Justice Ghosh, Milord, the same stand was taken, and thereafter in contempt they have also complied with. I have Milord given Milord that instances, Milord, I have annexed
Mr.
the
Bandyopadhyay, is it a fact that his properties have been utilized? Not
It
utilized.
is not that case, my lord. He has not annexed any document in support of that claim. My lord, in the paragraph he has stated only plot number 308 and 309 is involved.
Yes.
Paragraph number 3 of the writ petition. But in the instant case, my lord, there are 20 writ petitioners.
20 writ petitioners.
20 writ petitioners. They have filed this writ petition claiming their compensation, alleging that the land have been taken away in the year
And they have engaged Mr. Mukherjee.
in the year 1997 for construction of the embankment.
1997.
1997. After 20 years, they approached before the Honorable Court. And not only that, my lord, they have stated when the embankment dam was constructed, they have not raised any objection to that effect.
Mr. Bandyopadhyay, whether plot numbers 308 and 309 has been utilized.
Yesterday, my lord, we have received the brief at 5 p.m. My lord, therefore, I have no instruction. I am, my lord, only for them. But they have not stated any single land acquisition case number. Nothing have been stated. my
No,
lord.
he has said no acquisition proceedings was initiated.
No,
That's
but-
his case. He said it has been utilized without any acquisition
No,
proceedings.
that
That's
is their
his case.
allegation. Whether it has been utilized or not, that's what we are
No,
ascertaining.
that you have to
That's
ascertain.
what- that's
That
what-
you have
Milord,
to
that-
ascertain.
And after 20 years, they have only
That I have answered, my lord.
court, my lord, only saying that our land has been taken away and the land has been.
No, there are two ways of looking at it, Mr. Bandyopadhyay.
After
One
20
thing
years.
is that, yes, factually, if this plot has not been utilized, then they are not entitled to anything. Secondly, if the plots have been utilized, may not be Mr. Mukherjee's client, maybe other persons who may have right title and interest, they are to be compensated. For that, factually, they have to produce documents
Yes,
before
yes,
you
yes, my lord.
in support of their title
Milord.
and other things. You can verify all those because prior to passing an order of or direct purchase policy, whatever it might be. So you have to verify their entitlement first, whether these two plots were utilized. If these two plots were utilized, then who are the persons who may be entitled?
আমি বলতে দেবো না তোমাকে ওটা কোনটা ওইটা স্বপনদা যেটা দেখাচ্ছে ঠিক আছে
তুই বল না
Yes.
But they have annexed one document, my lord, the court order passed by my lord Justice Munshi.
Yes.
Page 44.
Page 44.
It's a similarly, but some is different. But there is a notice was issued for hearing, but the petitioners was not called for hearing. Therefore, this honorable court, my lord, has been directed the land acquisition collector to consider the representation and take in hearing and take decision.
I can also direct that.
Yes, my lord.
Page 47 kindly wants to page 46. Milord, the contempt order starts. Kindly takes up page 47.
Page 40.
Now, Mr. Mukherjee, first, whether you have right, whether these
That
two
Milord, my
plots,
learned senior friend can always
whether
come
these
with
two
their report.
plots- whether
But
these
they
two
made
plots
representation
have been
before the my lord.
utilized, that is to be considered. Then whether you are entitled to these two things are to be found out or to be verified before coming to a conclusion that you are entitled to any amount of compensation or
They made representation before the Milan Nirbahi Bastukorer Koron Nodia Sejo. That is the irrigation department.
page
Milan 55.
55.
Page 55.
You can consider that and take a decision.
By the irrigation department.
Irrigation is the authority because if it has been utilized for the purpose of embankment,
Yes, Milan.
you
So
can
that
tell
that
who is
has been
the-
utilized or not. If it is Milan, then consequent steps will be taken.
the irrigation department who has utilized.
Milan.
Or
That
if you
is
want,
their irrigation, Milan.
if you want, you can file a report also.
Yes, that will, Milord, rather not expedite the process. If I am Milord, then I will be out, Milord, at the first instance if my land is not.
সেটা বলবো না সেটা কেন সেটাই বলবো কেন সেটা বাইরেটা
So two things, Mr. Pondopadhyay, if
নেই তো সেটাই let it be disposed of by the considered by the concerned authority, Milord. Whether
who will consider,
they made representation before the executive engineer, irrigation department. No, department. Downly to
Executive engineer, Nodia Irrigation Division.
Whether this
Because
land has been
that
utilized or
department
not,
has utilized that property.
let them produce the document
And the
before
proposal has to go from that department. Asun.
I need to appear on behalf of the state.
I am for the private respondent number 8, 9, and 10.
Yes, what is this matter?
Matter is this, my lord, on the basis of the record of rights, in the record of rights, award has been declared. The petitioner, though they were the owners, but they did not make any objection at any point of time. And the record of rights was in the name of the private respondent, and award has been declared in their name. And now, my lord, they are claiming they have mutated their name in the year 2025 and come forward before this honorable court. Well, this is my instruction.
Yes, who is for the petitioner?
None, my lord.
Then they have to approach for apportionment.
There was 3G5.
My lord,
Oh, this is
Highways.
highways.
my lord, I would submit that this petition is not maintainable because
My lord, already, my lord, the apex court, I have brought the decision that record of rights, the collector is not duty bound to make a roving inquiry from the registry who is the owner, but it is on the record of rights as supplied by the BLR.
Has to be because some documents, though the record of rights do not confer title,
That
but
is, my lord, reported in, my lord, 1997 to CHN, Supreme Court, page 33.
1997 to CHN.
Supreme Court, page 33, West Bengal Housing Board versus BP Gupta.
None appears for the petitioner at the time of call. No accommodation has been sought for. Yes. Yes.
Matter relating to unauthorized construction over the PWD road, lordship. The private respondent constructed unauthorized construction over the
Private respondent served.
Served, lordship.
Received.
Received. Served, lordship. Served.
When they have received.
Lordship, kindly.
When they have received.
Lordship, yesterday or
Yes, Mr. Datto, what is your instruction?
My lord, the issue is, my lord, so far as, my lord, the question of at all there has been any encroachment or not, my lord, the demarcation process, my lord, has been initiated.
Demarcation done, started.
Not yet done. It started, my lord. The instruction
Assistant
is
engineer has written to the BLR
BLRO on
when?
16th of July. 16th of July.
So till November,
Till date, my lord,
how
no,
much time it takes Mr. Datto to demarcate?
my lord, I appreciate, my lord.
What you are appreciating?
My lord,
What you are appreciating?
yes. My lord, that the time, my lord, there is time has lapsed, my lord. Kindly, my lord, then directs them to.
So how soon you can do that?
My lord, within a period of 4 weeks, my lord.
Within a period of 4 weeks.
Lordship, my instruction, nothing has been done, lordship. Nothing has been done by the authority.
My lord, so far as demarcation, my lord, so far as the
Nothing
triggering
has
of
been
the
done. He is
mechanism,
also admitting that nothing has been
my
done.
lord, so far as the
He is saying
triggering,
he will do. Nothing has been done. He is also admitting.
if at all, my lord, the section 10 procedure would be triggered or not, it will depend on the, my lord, finding in the demarcation.
That has to be. Show me the letter. Where have you given the letter? Show me
My
the
lord,
letter.
kindly. They had a copy.
Ashun. The petition. for the assistant engineer to decide.
My lord,
Only thing is to serve a notice of removal,
Yes, ma'am. Yes.
my lord, affidavit of-
fixing a time limit.
Very well. My lord,
Time
if at all-
takes in
if at all,
demarcation.
Lordship has mentioned that, my lord, if any.
My lord, affidavit of service kindly be kept on record.
উপরে লিখে দেবেন if is service take.
Madam, my lord, we beg to appear for the petitioner, my lord. Mighty is leading me through online.
I am for the state respondent, Lordship.
I am appearing on behalf of the respondent number 8.
Yes, where is Miss Maiti? Yes, what is this matter?
Matter, we have challenged the, my lord, the impugned order passed by the, my lord, this special, my lord, the acquisition officer.
Lord, Lord, I beg to appear on behalf of the petitioner, if your lordship.
Yes, yes.
This is an order passed by the Lord at page Lord impugned order under challenge before your lordship. At page 118, your lordship kindly have a look to.
No, 118 is the
Lordship.
118, yes.
impugned order is, my lord, 136.
Sorry, my lord, sorry, 136, your lordship, 136.
Yes, yes.
Page 136, my lord, your lordship will find. This is the final order.
Yes. What is the wrong in this order?
In this order, wrong is this, my lord, I purchased land measuring 33.5 decimals from the vendor.
Yes.
India 1993 by registered deed, my lord. The land acquisition procedure was started in the year 2006-7, and my property was entire property was acquired. I was given compensation only in respect of 22 decimals of land, and the rest portion 11.5 decimals was not paid to me. This is the subject matter of my grievance.
What did the special land acquisition officer say?
I am coming to that, my lord. Specifically, it was held that
But that one repetition was page 136, my lord.
Yes, what is the finding?
finding is, my lord, chain deed are not, my lord, similar and identical to my purchase area. I have, my lord, already collected other two deeds to show your lordship that what would be the, my lord, this similarity I do not know, my lord, but it has held that no similarity is there. My purchase deed is not denied.
Lordship, I am for the
What is
state,
the
Lordship.
instruction?
Lordship, it is not that case, Lordship. Lordship, case is the petitioner purchased land 33.5 decimal of land. But his name was recorded in respect of 22 decimal of land. The land was acquired full 10,000%. That is 4 acres of land from which his land.
Award declared.
Everything has been done.
So in respect of this plot of land, where is the copy of the award? Please show me the copy of the award.
Yes, my lord, yes.
Passed an award.
Grateful to your lordship. This is my prayer before your lordship. Let him produce the record, my lord.
Miss Maiti, please allow your learned
My
friend
lord,
to make it
my lord, your lordship.
Lordships, the land he made an application under section 50 of the Land Reforms Act before the BLL first. That application was rejected. Thereafter, he filed an application.
Mutation neither creates title nor extinguishes the
No,
title.
Lordship,
There are two things.
otherwise, Lordship, how the award will be made in
No, I'm not saying award has to be made in her name.
Yes.
Please show me the copy of the award in respect of this plot of land. Please show me.
Lordship,
You must be having the copy of the award.
Lordships, that is not in the file, Lordships. I'm just
That's
for
the
the
only
file.
document.
Tomorrow.
You have to show that this is the plot, this is the area which was acquired, this is the award calculated in the name, may not be in the name of Mr. Maiti's client, maybe in the name of Mr. XYZ.
In the order passed by the appellate authority under section 54, that has been stated.
Not going 54 mutation, no
Not
mutation,
Lord.
title. Let us for the moment accept this Maiti's client
the-
do not have any title.
Yes, yes.
Please show me the award.
Lordship,
In whose name you have passed award?
award
regard
in respect of her name 22 decimal of land and rest of the other owners, Lordship.
Show me that.
Lordship,
End of the matter. Then if you have declared the award in the name of the
Other
recorded
person
she has other remedies
and
she
this
has
was
to-
the award. This was the award in the name of the awardees.
That show me
Lordship,
the
tomorrow,
when
today
can
for
you
the
produce the award?
কোন district এটা? বহরমপুর।
That's the only
মেদিনীপুর,
document.
Lordship. Within 10 days, Lordship.
All right.
I did Lordship.
Lordship, 2 weeks, Lordship. 2 weeks.
10 days when I said yes, now you are saying 15
No,
days.
Lordship, no, I'm not saying, Lordship, because I'm 10 days, I have some difficulties because I saw understand, Lordship, with regard to other person. Lordship, that may be 10 days, Lordship.
I did Lordship.
All right, 15 days. You have said 15 days, 15 days. So, the petitioner
99, my lord, RS tag number.
RS tag number.
199.
In the notification, RS tag number or ILAT tag number?
The notification.
Acquisition notification.
RS below 64. RS plot number below
199.
Where is the notification? Have you annexed the notification? Notification mentions RS or LR plot number. Then you will come with another round of controversy. RS is this, LR is that. Please be specific.
It is RS tag number.
Where is the notification?
RS plot Khotiyar number 64. RS plot number 199.
আচ্ছা ঠিক আছে স্যার কি বললাম পিটিশনার things number where
In the paragraph.
Was
Ele-
acquired
Lordship,
for the project Telcon.
Sorry. 59, there was no mention of this RS or LR. Only tag number
190. Lordship, my another submission.
I said RS, I have recorded
RS. I'll submit, Lordship, against the order of the LRT. He has not appeal, Lordship. He has not prepared any LRTT.
I'm not going
And Lordship,
into the issue of
No, LRTT has got no power. LRTT was not.
I'm not going into the issue of mutation.
No, LRTT is not.
The correct
Even if
authority.
not mutated in his
We have
name,
approached to the my lord, this honorable court passed the
cannot
order
be
on the basis
extinguished
of that order.
does not
My lord, the
extinguish
special
the
acquisition officer has passed
only
the order.
thing you have to show, because if you have acquired the entire portion,
So
you have to pass an award for the
Yes.
entire portion.
Yes.
I have to only see
Yes,
in
yes.
whose names you have.
Yes. That is
I'm grateful, deeply obliged to your lordship.
Next, call the next matter.
I am
Change will matter to appear.
এটা বোধহয় কালকে লিস্ট এটা কালকে লিস্ট ছিল 14 yes
Lordship, I am for the petition. Lordship, allegation of unauthorized occupation over the occupant over the PWD's land, my lord, and a semi-permanent structure over the plot of PWD in from
You want all illegal constructions to be removed. No illegal constructions will remain.
illegal construction, semi-construction, my lord, page 41,
No illegal constructions will remain. You don't want any illegal constructions to remain. Say yes or no.
Yes, my lord. Yes.
My lord, I am for the state, my lord, in this
Yes.
matter. Here, my lord, I have received this particular, it's similar to 12, item number 12.
Demarcation
Yes.
request has been made.
On the 26th, it has been sent to the BLLO. BLLO has received the same on the 27th of this month. The process
27th of this month.
this month. You waited for 2 months. I must be candid. I will not be. It is under process, my lord.
So I'm giving 4 weeks time to
My lord, I am for the-
complete the demarcation.
And the notice to be given to the executive, this thing, I mean, the executive
Assistant
magistrate.
engineer.
Executive magistrate also after assessment.
After that, it will be done.
Yes.
Let the
As per section
assistant
10,
engineer
whatever,
do
yes.
that, he will
Yes,
follow that.
yes.
So his duty is to forward
Yes,
to
it's just a forwarding.
My lord, I am for the private respondent. My lord, I should be candid. My lord, I am yet to receive the my lord Bhakalatnama. Within 2 days, I will get. My lord, I am giving the undertaking to file it in due within 2 days because I am yet to receive, but I have instruction to appear, and I am denying dispute that this is not my construction. I am denying, my lord, this.
This is not your construction.
Yes, we have not erected anything, my lord, over the PWD road.
There are 2 private respondents in this matter.
You are representing both of them.
No, my lord, I am only one. Respondent number 5, I am representing.
Only one private respondent.
Oh, one, man. I'm sorry.
So you are representing.
Yes, only.
Ashok.
I'm sorry.
If your service filing code today is আপনার সাবমিশনটা করেছি
Appear for the petitioner, my lord.
Yes.
The petitioner is the owner of a plot of lands, my lord. Wherein, my lord, he carries out agriculture activities. Page 16 is the details list, my lord, wherein, my lord, he has stated about the land which he is owned. And a private respondent is basically person who is involved in carrying of pisciculture. Now, his land is a agricultural land. The other
Whose land is agriculture?
petitioner's land is a agricultural land wherein he cultivates agriculture. The remaining portions of that already has illegally converted into pond, my lord. For which now, my lord, water is coming into.
Private respondent has converted.
Yes. Now, my lord, for such draining of water, my agriculture activities have been affected. I have already.
What is the inaction on the part of the state?
Kindly sees, my lord, page 26 once, my lord.
The private dispute.
Is illegally converting water body for which my agriculture has been activities have been stopped, my lord.
You are for the private respondent. Yes. Why are you converting?
Kindly comes to page 26. The BLRO has also accepted it, my lord. Approximately 80% of the land are encroached by artificial pond in the said Moja.
What is the DAG number?
That time I was kindly comes to page 31 in the representation. I have given the details, my lord. I want this.
What is the DAG number? These DAG numbers?
Yes.
So many?
Yes.
What is the classification in the record of rights?
Jol. Jol. No, Jol. But Jol, my lord.
Agricultural.
Yes.
Mendipur.
Yes, my lord.
Jol is agricultural, not
Jol is agriculture. My lord, kindly the plot
Initially,
number which have been
Mendipur, it's agricultural.
First, code number 1, Jol agriculture.
Yes.
So
that is why I asked you which district.
No, my lord,
Mendipur, Jol is agriculture.
but the plots number which have been given the relating to the ownership
Why
of
you
the
are taking
petitioner.
steps for illegal conversion of
My lord, I have already, my lord, intimated the block land and reform officer.
No, what steps did he take?
My lord, no plot, no plot number was given.
At that time,
No.
at that
Plot
time,
numbers have been
but
given.
that time I was not given.
Which time?
But earlier that was not in my representations, my lord. But subsequently I have given, my lord. In last, my lord, on 10th of November, let this representation be considered and appropriate steps
10th
be
November given the
Where is your representation?
by page
31.
31. I have in details given.
Yes, Mr. Mahato, please consider.
Let it be
But
considered.
if 4C and 4D is applying, then the tribunal is the authority to consider this evidence.
Take that point.
My lord,
Yes.
another point, my lord. This is a non-joinder of party, my lord. Landlord has not been party in this writ petition, my lord.
Who's landlord?
Who has converted the land?
Who are you?
I am the lessee of the land.
You are the lessee.
Lessee. I am the.
What is the name of the lessor? Please supply the name of your lessor.
Yes, my lord.
Yes. Please add him. Serve him a copy. Where is the name? Please.
There are so many.
Please give me your lease deed.
Yes.
Give me your lease deed.
So many.
Notarize this deed.
There are so many landlords, my lord.
There are legit down. কতজন আছে? 22 জন। হুম?
21
এই প্লট গুলো উল্লেখ করেছে এই রিপ্রেজেন্টেশনে নাম বললো তো প্লট গুলো ঠিক দাও এই প্লট গুলো নেই মনে হয় উল্লেখ দেখো তো এইগুলো উল্লেখ করেছে প্লট গুলো আগে উল্লেখ করেছে কিনা দেখো রিপ্রেজেন্টেশন
এই তো আমার প্লট গুলো কথা বলি ওদের প্লটে তো আমি বলবো না ওদের জন্য তো আমার জল হচ্ছে
ওদের প্লট না দিলে এনকোয়ারি হবে কি করে যাক প্রাইভেট রেসপন্ডেন্ট তোমার কেসকে হেল্প করবে প্লট গুলো দেবে
Notarization done when?
But sign before that, my lord. Lordship kindly see.
This
Lordship
is,
kindly say
but
agreement.
how could this notarization be done? What is the effect of notarization?
2nd December.
This is a deed document of 26th of May 2017 and notarization done on December 2025. This original document.
My lord. That is
How it was notarized? How the notary identified? What he has identified? All right. Now you want to take it back? Take it back.
Say 2nd December.
Let it be. Did we made a party of petition landlord?
Sir, if you make up, say that, I will take it on record. I will initiate proceedings against you. Notarization done.
Done on 2nd December.
How that notarization could be done? I will call the notary before the court.
After long.
So, what does the notary do?
To identify the
persons.
The document signed in 2024. None of the parties were present. He is notarizing those signatures. Can it be done?
No.
And yesterday it was done. Today the matter is fixing in.
This check before handing up any document before the court. কি বললাম? বলিনি কিছু। আচ্ছা। Petitioner
My lord, I am for the private respondent number 9 and 10.
Yes.
Lordship, this is my affidavit service, Lordship.
You're for the petitioner?
Yes, Lordship.
Yes.
Lordship, the petitioner, he purchased a land, Your Lordship, about 8.5 kathas by the side of Canning Highway, Your Lordship, to build a hospital, eye hospital, Lordship. Now, what has happened is, Lordship, the private respondents, they have constructed a structure there, Lordship, thereby blocking totally my road, everything, Your Lordship.
PWD road?
PW road, it is a Noyanjali, Lordship. Lordship will kindly come to, I'll show you only 3 pages, Your Lordship, kindly come to. Lordship will kindly come to page 40.
Yes, what is your instruction? You are for the state.
I appear for the state because I received the brief only on Monday, well, in the morning.
All right.
So, I could not.
Tomorrow?
Tomorrow, Lord, your lordship, kindly give some time, Lord.
Why? Where it is?
Canning.
Canning, Your Lordship.
Canning, how far it is?
No, Lord, and BLR is not at first of all, Lord, it has to be ascertained whether, Lord, it has been encroached or not, knowingly has been converted or not. It is whether, and BLR is not.
I have annexed the photographs even, Your Lordship.
All right, so consider this representation.
Yes, that Your Lordship can.
Lordship, collector is the authority, Your Lordship. Collector, district collector is the authority, Your Lordship, under this act, Your Lordship.
And
Which act? 62 Act.
West Bengal Public Land Eviction.
Public land, I do not have determination. For want of determination, this matter for.
Lordship, let this go to the appropriate bench. Your Lordship.
Parties will be. Seventeen din. Yes, Mr. Banerjee, you are appearing.
No.
Was title running to 73 pages, 68 pages.
One court case, once.
None appears for the. একটা বাজেনি এখন এসছে দেখে দিন পরেরটা তারপর দেখি
I am for the petitioner, my lord. In this matter, my case was that land has been taken for construction of bath, but compensation not taken. Embankment. Compensation not paid. Mr. Bandyopadhyay submitted that these plots mentioned are not part of any acquisition. After that report, I have prepared a map, my lord. I find that there are some plot numbers which have not been mentioned by mistake. Not original plot number is mentioned, RS plot number that was bifurcated. So I kindly, if your lordship allows me, I'll.
Mr. Banerjee, the petitions, in the representations, you are giving vague plot numbers in all matters. None of the matters correct plot numbers.
I told my junior to sit with the client and prepare both CS and RS. This has been prepared. Not two plots are there. Now she will similar the embankment.
Then what do you want?
I'll withdraw and file afresh because supplementary will not be.
I think that's better.
Original is 842. Copy nahi hota.
দেখি ফাইলটা দিন Mr. Banerjee, both matters you have to withdraw.
Both matters.
দুটো ম্যাটারই একটা অর্ডার করে দিন matter? ও এবার হয়ে গেছে।
Nine zero, 90.
Yes.
Review applicant, my lord, kindly recollect in this matter. My lord, after closing of my argument, which my lord I could not point out, my lord, to your lordship at the time of my lord argument, that after closing of my argument, I am defendant in the suit. After closing of my argument, plaintiff had taken out an application under order 18 rule 17. That was standard by the learned. Your lordship allowed this. But only two things, my lord, my lord, could not point out. Because, my lord, one is that, my lord, after closing of my argument, that, my lord, would cover, my lord, Veluswamy judgment, my lord. Second is that, my lord, power of attorney holder, who is PW.
Power of
Attorney holder, who is PW1, who deposed in the, my lord, landed court below.
Yes.
That, my lord, author of that power of attorney, my lord, that is the plaintiff, he died. Whether he can be recalled or not, my lord. Because there is no power right now. Only for these two grounds, my lord, I have, my lord, favored this, my lord, review application. Yes. This is, my lord, kindly see the order number 117 dated 36/2025.
No, where is the impugned order in the civil division application?
My lord, that is in the civil division. Order number, my lord, 122 dated 12 August 2025.
Order number?
12th August 2025. Order number 122.
Show me the finding of the learned trial judge with regard to that.
The second paragraph, this is the submission of the defendant. May I read, my lord? Defendant filed written objection against the instant petition. As your lordship got it, my lord, second paragraph.
Yes.
Instant petition submitted that the instant petition is not maintainable in law, and in fact, it is further submitted that the original plaintiff, namely Fulkumari Devi, represented through her power of attorney holder, namely Pradeep Sharma, and he deposed as PW1 in this suit, and his deposition was concluded on 6/4/2016. That the original plaintiff died on 2nd January 2019, and thereafter the said power has automatically been seized, and as such PW1 cannot be recalled. That after closing of the evidence and completing the trial and the stage of argument where the defendant completed argument on his part, the plaintiff filed this instant petition to fill up the lacuna in the evidence. Previously filed an application under order 18 rule 70. That was standard. Thereafter 151.
The previous order 18 rule 17 was rejected.
Rejected.
On what ground?
That on the same ground, that will your lordship will find order number 118 of
Now,
5.
Mr. Das, you are appearing for the other side.
Yes, madam.
Mr. Das, if the power of attorney holder is deposing and the person has died, he cannot depose.
My lord, subsequent kindly see the penalty made page. Penalty made page of the order impugned. Last.
Of the?
Yes, last one.
Which order?
Impugned order.
The order under review.
Impugned order. Under.
Yes.
Impugned order. Last one.
Last.
Penalty made page bottom. Last paragraph. Last but not least, it is to be mentioned that the present plaintiffs have filed a fresh part of attorney.
Page number.
My lord, certificate copy page
Last
3.
paragraph.
Page 3.
No, what is the paragraph number?
Last one. Bottom last.
Paragraph number.
Paragraph number, my lord.
You are referring to which order?
The
Order under review or the
impugned order?
Impugned order in the civil revision application?
Lordship.
All right. Yes.
Lordship.
Order dated 12th of August 2025.
Yes, my lord.
Yes, which page?
Penultimate page, page 3. Page 3, bottom.
Penultimate page, yes.
Bottom.
Last but not least, yes.
It is to be mentioned that the present plaintiffs has filed a fresh part of attorney executed in favor of PW1. And as such, I find no relevance in the submission of learned advocate for the defendant as to the locus standi of PW1 to adduce evidence in the suit, if otherwise allowed. We have already given a power of attorney, fresh power of attorney. That part is dealt with.
Only one thing, Mr. Das. This PW1 deposed on his behalf. Yes. On whose behalf?
Behalf of the original landlord.
On behalf of the original landlord.
She died.
She died.
Substitution of his legal yes already made. They give power of attorney to the
What are the points for recall? Please show me.
Points?
What are the questions?
Yes,
Put some questions
yes,
to the
documents. Some documents left in the custody of the original landlord. After substitution, this petition.
Show me the Order 18 Rule 17 application one.
On the 23, page 23 of the revisional application.
It is, my lord, page 23. Page 23, my lord. First, 151 application has been filed. That has been turned down. Then this application, present application
page
filed.
23.
Page
23
23.
of the revisional application.
Of the revisional application.
Yes. No, revision application ta kothay? Revision application ta? Not here. Only the review file has come. Yes. Now what is the difficulty?
Difficulty is after closing of my argument.
That has been decided. With regard to the power of attorney holder, that has been decided in cave
Your lordship says,
after your argument, everything.
No, your lordship says, my lord, kindly says, my lord,
yes,
order
power of attorney holder, the original person has died.
Yes.
So he deposed, subsequent substituted plaintiffs have also given there, and that was.
No, he said that as a PW1. Kindly says the application as a PW.
All right. Then I will allow them to adduce further evidence. If you want that, I will allow them to adduce further evidence. He will be marked as PW2. That's no difficulty on that. I'm saying that that person will depose as PW2, not as PW1.
And after closing of my defense, after disclosing my defense.
That point has been decided.
No, that
point has been decided. Now it is.
No, I have very inception. I said, my lord, that is I failed to indicate.
No,
your lordship. No, your lordship recorded argument of the plaintiff is over. That is, my lord. Defendant is over.
Show me where I have recorded only argument of the plaintiff is over, and show me that the defendant's argument was also over.
Yes.
Show me which paragraph I have recorded.
Because of that, my lord, I am supported by the Velusamy judgment. Because after closing.
Show me where I have recorded that.
My lord.
170.
Show me where I have recorded that only the plaintiff's argument has been closed.
1 minute. Paragraph number my submission, my lord. Paragraph number 5.
Paragraph number
5, my lord.
yes.
The learned advocate appearing for the opposite party submits that the petitioner were all along in possession of such document and for reason based known to
The evidence of the parties have already been concluded.
yes.
Do you have a copy of the Velusamy judgment?
Velusamy judgment
Please show me
and
which
decision
paragraph
judgment of
supports you. Please show me which paragraph supports you.
I'm latest judgment, my lord. That is, I'm relying that.
No, I have not. I cannot consider any further judgment.
It is relied upon the Velusamy.
Velusamy. No. Maybe it has relied upon Velusamy. Please show me Velusamy's judgment. Subsequent judgments not relied upon by the parties in review. I cannot go into that. You have a copy of the Velusamy's judgment?
May I hand over, my lord?
Yes. Please give me. Take a Velusamy's judgment. Last paragraph. Last paragraph of Velusamy's judgment.
Velusamy টা আনোনি? ওকে না দিয়ে ওদের দিলে ঠিক আছে? ওদের দিক। কিন্তু আমার এভিডেন্স বিশাল হয়ে যাবে, কিন্তু ফিল্ড হয়ে যাবে। সেটা চিন্তা করো। ওকে তো লিমিটেড স্পোর্ট রিকর্ড করবে। তো সবাই হতে আবার প্রথম থেকে ডিনোভ হয়ে যাবে। ভ্যালুসামিটা বার করো না এর থেকে। এই যে 2011 এসএসসি প্যান্টটা আনোনি? 11 এসএসসি 275 ক্যাপ্টেন
Ashwin. This is an application
Yes.
Can, what is can? Can for stay.
For, I think, my lord, for appropriate order. This,
Oh,
yeah.
can টা
Yes, and
কোনটা? Mhm. Yes, who is appearing?
Item 59 monthly list.
For the petitioner? Yes.
My lord, I also, my lord, as per direction, my lord, I also served the notice to the, my lord, other side.
You are for the state. Who is for the private respondent?
My lord, private respondent, my lord, Subhajit De. My lord, he, my lord, give the no objection to my lord Taroknath Sarkar. I also informed to him.
You have
My lord,
informed Mr. Taroknath Sarkar?
Yes, my lord. At the time of my lord informing, he was, my lord, in Salt Lake.
Yes. What is this matter?
My lord, my grievance before your lordship, my lord. I filed this writ application, my lord, for ingress and egress of the petitioner and, my lord, the illegal encroachment of the, my lord, PWD road in front of the, my lord, petitioner land and, my lord, house. My lord, that after, my lord, make the, my lord, letters and represented to the, my lord, respondent authority. My lord, the respondent authority, my lord, they are issued notice to us, my lord, 12th day of August 2025 for taking the necessary action. My lord, this is the, my lord, first notice. And thereafter, my lord, after verifying the, my lord, encroachment land and property, my lord, that on 3rd November 2025, the assistant engineer, my lord, issued a, my lord, another notice to us and, my lord, petitioner also. My lord, I handed over to, my lord, notice to the, my lord.
Nothing has been disclosed in the writ petition.
My lord, after
No, it is
filing,
after filing of the
filing,
petition.
Then you could have filed a supplementary affidavit.
Kaji, your client ought to have given you this instruction, this notice. What is it? You have taken steps. That is, he is saying that you have taken steps. And you are saying supplementary affidavit. Yes.
And, my lord, by notice dated 3rd November 2025, my lord, the assistant engineer.
Now,
the
thereafter
direction
nothing has been done. No steps have been taken.
No step has been taken. Not only that, my lord, yesterday, my lord, the petitioner received the deadly, my lord, threatened from the unknown number, my lord, from the local mandal.
10-1, 10-1. Please see this. Please give a copy.
Yes, my lord, I handed over to my lord copy.
So 10-1 also you have issued a notice.
Yes.
So complete the entire process.
Yes.
Within a time.
And, my lord, during time, kindly give protection to the petitioner, my lord.
How that?
His, my lord, family also suffer from the political vendor. Who are the, my lord, today, my lord, the
That is not on record.
position.
That is not on
For
record.
that you have to have made a complaint.
My lord,
Make a complaint. There is a provision.
I know, my lord, but my lord, all everything
There is a
has been
provision
my lord,
under which act, which statute, which regulation.
Let it fall under the my lord, police inaction and my lord, police complaint.
Police inaction is not a statute. Under what statute?
My lord, police act, my lord.
No. Bharatiya Nyaya Samhita.
Not police act. Asu. Petitioner claims to be Yes.
21.
Lord, I appeal for the petitioner, my lord.
Yes.
Today my turn to, my lord, reply the argument placed by my learned friend on the last occasion.
Yes.
He assured the court that he will confine his reply.
Yes, within the law points.
On the law points,
My lord.
particularly whether directory or mandatory.
My lord.
issue.
My lord.
No.
That is notice or serving of the order 3-1.
Yes.
3-1.
3-1.
My lord,
Yes.
the first, my lord, point, my lord, which I placed before lordship, my lord, that my learned friend submitted before lordship that as the name of my father was not recorded anywhere, so they were not in a position to serve the notice upon my deceased father, that no record was found whether.
Chakraborty, please do not go to facts. Please reply on the law points.
One-
Whether it's
only-
mandatory or directive.
No,
Please
my
do
lord.
not. Those facts you have argued from the day one. Record of rights, whether record, not record.
not that.
Don't go to that.
But only
Please
one
answer
page.
the law point.
But for my satisfaction, only one page. Only one page, 64.
Mr. Chakraborty, you have assured that you will be arguing on the law points.
Law points, my lord.
Again,
Because, my lord, in the award sheet, the name of my father is appearing.
Yes. All right.
But no amount, no, my lord, description of the land.
Yes. Page
64.
Yes.
That is why, my lord, I am showing your lordship that the contention of my learned friend is not correct, my lord. My lord, second name. My lord, Kamakya Ranjan Datta, son of late Kamakya Ranjan Datta of Rajnagar Chakraborty Para, Calcutta 78, where this is the award sheet. My lord, this is, my lord, submitted by the state in the, my lord, earlier round of litigation.
Yes.
So, my lord, my humble submission that my father was in occupation and my father was the owner of the property, it was well known to the authorities. In spite of that, my lord, no notice under section 3 has been served upon him. And my lord, why this has happened? My lord, in the first phase, my lord, as the my father's property was covered by structure, that portion was not acquired. That's why, my lord, my father's name is there, but no award, no amount, no compensation. But this is only the factual aspect, my lord. Now, my lord, my lord, on the basis of, my lord, mandatory or, my lord, directory. But in the Shoyendra Pal's judgment, my lord, the division bench, my lord, discussed about 3 judgments passed by this honorable court, single bench, my lord, wherein, my lord, categorically stated that service of 3-1 notice is mandatory. And considering that,
Mr. Chakraborty, how it is decided whether a provision is mandatory or direct?
my lord, that is when, my lord, that is, my lord, I will show your lordship from the statute. Before that, my lord, one of the judgment which my learned friend has, my lord, relied upon, that is, my lord, paragraph 25 of
a provision is to be interpreted as directory or mandatory.
My lord, I will
please show me.
I will show your lordship, my
on
lord.
that line.
I will show your lordship, my lord. What would be the consequences?
Yes.
What would be the consequences, my lord?
Yes.
First, my lord, kindly have a look, my lord.
With the consequences, that is one of the tests. There are other tests as well.
Yes. And my lord, not only that, my lord, when this act was enacted, my lord, at that time, my lord, the general, my lord, law, Land Acquisition Act on 1894 was in existence. My lord, that's why, my lord, I put this question to myself, my lord, what necessitated the state to, my lord, formulate this statute? Only to, my lord, my lord, for this act has been, my lord, promulgated only to, my lord, for some specific purposes. For some specific purpose. And that has been, my lord, discussed by the, my lord, coordinate bench of this honorable court, which has been reported and relied upon in Shoyendra Pal's judgment, my lord. My lord, kindly have a look, my lord, power, section 3 of, my lord, that Act 2 of 1948.
Act 2 of 19, Requisition and Acquisition Act, West Bengal Land.
আমার কাছে তো একটাই আছে।
I have.
My lord, kindly have it, take my mobile.
You place it. You are having another copy? No.
This is,
No,
my
you
lord,
place
very,
it from. You place it from.
very rare one.
You place it. Yes.
My lord, Section 3, my lord, provides, my lord, power to requisition. My lord, that, my lord, my learned friend has placed before lordship, my lord, the power to requisition. My lord, here, my lord, the provision has been made to, my lord, make requisition of any property.
এই বইটা আছে
ওটা দিন।
হবে
না, এর মধ্যে নেই, ল্যান্ড অ্যাকুইজিশন অ্যাক্টের মধ্যে নেই, এটা আলাদা।
পরের বইটা থাকবে তো ও নিজে বুঝতে
একটা ওয়েস্ট বেঙ্গল লজ আনিয়ে নেবেন, তো তার মধ্যে এটা আছে, ওয়েস্ট বেঙ্গল লজ এর মধ্যে।
Power to requisition. My lord, I am skipping, my lord, that provision, my lord. Now, my lord, kindly have a look to, my lord, section 4 of that act. 4. Acquisition of land. Where any land has been requisitioned under section 3, the state government may use or deal with such land for any of the purposes referred to in subsection 1 of section 3 as may appear to it or to be expedient. The state government may acquire any land requisition under section 3 by publishing a notice in the official gazette that such land is required for a public purpose referred to in subsection 1 of section 3. Lord, my humble submission before lordship, my lord, unless a valid requisition is made, well, under this act, no land can be acquisition.
So, Chakraborty, there is no dispute with you. I am not for a moment disputing that proposition.
My lord.
I'm not saying that even if there is a valid requisition is not valid, it can be acquired under 4.1a. I'm not for a moment saying that. I'm asking you to show that this 3.1 serving of the order is mandatory. Please.
But this language of section 4, my lord, makes it mandatory, my lord. Unless, my lord, validly requisition, no acquisition can be made. The consequences.
Yes, unless there is a valid requisition. So when can a valid requisition be said to have been done?
But if the rules and, my lord, the provisions of the
why whether those rules says it is to be served upon whom, rules, I think rule 3 or 4 specifies that. Mr. Talukdar's argument is that that's even if there's any irregularity in service of that order, he does not say no, there is no necessity. He says even if there is an irregularity, that does not vitiate the requisition. That's the submission, specific submission made by him, by saying that it's a directory, not a mandatory. Even if there is irregularity, that will not vitiate language or the argument he is borrowing from Order 9, Rule 30. Non-service of summons is a ground for setting aside, but irregularity in service of summons is not a ground for setting aside. So he's trying to develop his argument from there. So he says that even if there is any irregularity, that will not vitiate the requisition. What is your submission on that? In that light, he says that this provision is not mandatory, it's directory. So only a simple answer on that.
My lord.
Show that it's mandatory, end of the matter.
Unless
only
it is
short.
unless it is
saying you are going to 4.1a, that unless there is a valid requisition, there cannot be acquisition. These are well settled.
My lord.
I'm not for a moment disputing that.
My lord. Then, my lord.
For that, you need not cite decisions. You need not go to 4.1a.
My lord.
That's well settled. So, but show me that whether this provision, service of an order, whether it's mandatory or directory, because you are relied upon a division bench judgment, he is relying upon a Supreme Court judgment saying, no, even if it is not served, requisition cannot be vitiated. That's his submission. Reply to that only.
My lord, in my lord, paragraph 18 of that, my lord, Sudhindra judgment, my lord.
Yes.
My lord, what my learned friend has submitted, that the validity of that, my lord, requisition point was not, my lord, taken for consideration. So, my lord, kindly.
Mr. Chakraborty, he does not say that. He says that it has been said unless it is served, it is required to be served.
My lord.
That's the finding. I think please kindly come to Shailendranath Pal.
Well, paragraph 8
of service. So rule 3, not rule 4. Rule 3 was taken into consideration. Then the submissions were noted. Then ultimately the finding.
That if it is not a valid requisition, no acquisition can be taken.
The order is not served.
Yes.
The requisition is not valid. He says by relying upon the Supreme Court judgment. Yes, please kindly come to paragraph 40. The order of requisition passed in respect of cannot be held to be valid for not complying with the required provisions under section 3.2 of the Act,
My lord.
because 3.2 says relates to service.
Service.
3.2, if you kindly come to 3.2, an order passed under section shall be served in the prescribed manner on the owner of the land, and where the order relates to of an author not being also answered. So, this 3.2 says order is to be served. Mr. Talukdar says it's directory, not mandatory.
Well, in that event, my lord,
Use of the expression shall, though it has been used as shall, he says it's directory, not mandatory.
no, my lord, in that event, my lord, section 6 of that, my lord, act will not take place. The consequence is, my lord, if no acquisition is, my lord, taken place, the further consequences of by virtue of that requisition cannot take place in by virtue of the statute. Section 6 says, my lord, release from requisition. My lord, if my lord,
6, yes.
my lord, if my lord,
6.
where any land requisitioned under section 3 is not acquired and is to be
Section 6 is a different thing. Section 6 is a different thing. Requisition made,
my lord,
valid requisition,
my lord,
not followed by acquisition.
my lord,
Then it has to be released from requisition,
my lord,
because requisition cannot be for a permanent purpose.
my lord,
And you cannot keep a
my lord,
land under requisition for eternity.
my lord,
More so after the lifetime of this act
my lord,
stood expired.
my lord,
So this is section 6.
my lord. Well, my humble submission, my lordship, my lord, that my lord, the consequences of a valid requisition are stated, my lord, in this section. My lord, if my lord, for an example, if my lord, the land is requisition and my lord not my lord acquired.
Section 6 proceeds on the basis of a valid requisition.
That is my
Valid requisition not followed by acquisition. It does not say if the notice is not served, what will be the consequences.
My lord, the judgments, my lord, relied upon, my lord, in the Solendopal's judgment, my lord, 3 judgments
Deals with this mandatory or directory.
Yes, mandatory. It has
Show
been
me that.
stated.
Show me that.
My lord, marking is there, paragraph.
It will help me. Unless it goes against you. Yes.
My lord, I will not take your losses so much time, my lord. Now, paragraph 10. My lord, first of all, my lord, my lord,
Paragraph 10.
My lord, judgment reported in my lord 1989, volume 1 CLJ.
1981.
89.
Okay.
Volume 1 CLJ, my lord, page 214.
214.
Oh.
Yes, show me where it has been held. It is mandatory, not directory.
My lord. My lord, paragraph 13, my lord, not
13.
13. এখানটা দেখো তো কোথায় ম্যান্ডেটরি বলে আরো আরো জাজমেন্ট আছে paragraph 10, 11, 13, 14.
Show me where it has been considered directory or mandatory.
1 minute, my lord. My lord, paragraph 14, last portion. Accordingly, I hold that in the instant case there was non-service of notice upon the occupiers who are entitled to get a notice as occupier.
If there is non-service, it amounts to violation of 3.2.
My lord,
No
3.2.
difficulty on
My
that.
lord, 3.2.
Non-service, so 3.2 has been violated. But where is that issue of
Yes, my
mandatory and directory considered here?
This is my lord, my lord Taroknath Sen and my lord Dhinasar Finance Limited, my lord,
Please show me that portion only, that it considers
Yes.
the effect of this expression shall used in section 3.2.
My lord.
And it has been held to be mandatory and not directory.
My lord, yes, I have got. My lord, page 230. My lord, citation is my lord, 1992, volume 1, CLJ, page 222. My lord, page 230. My lord.
Page 230, yes.
230, my lord.
292.
My lord, first paragraph, my lord, that's my lord, last portion. When the legislature makes it clear that under section 2, my lord, got it, my lord.
Yes, yes.
3.1 shall be served in the specified manner in the or to the owner of the land, and what the order relates to land in occupation of an occupier not being owner of the land also as occupier, considering the scheme of the act, such provision is a mandatory. Such provision is a mandatory, and that order under section 3.1 of the said act could only be effective only on service as provided under subsection 2 of section 3 of the said act.
Yes.
In the instance the order of requisition has not been served in as provided in subsection 2 of the said act.
Yes.
It has been well stated mandatory. Now, my lord, Taroknath Sen case, my lord, I will, my lord, place, my lord, only 3 paragraphs. Well, it is reported in 1993, volume 1, CLJ, page 371. Paragraph, my lord, 4.
371. Paragraph
4, 5, and 8. My lord, paragraph 4, at the last portion of lordship kindly come, my lord. The respondent authorities do not seem to have acted in any manner to make any inquiry or to verify the said fact. Therefore, I must proceed on the basis that it is not seriously disputed by any cogent or reliable evidence by the respondents that the petitioner are the owners of the premises in question. The petitioners admittedly had not been served within. Therefore, it is manifest that there has been a breach of the mandatory provisions of the requirement of subsection 2 of section 3 of the Act. But relying upon these judgments, my lord, the Solendranath Pal's judgment was delivered by the division bench of this honorable court. My lord.
Yes. Anything more?
Now, my lord, my humble submission before lordship, my lord, when, my lord, a general law was, my lord, was in existence, my lord, this law, this, my lord, special statute has been enacted, my lord, for some specific purposes. And, my lord, the difference between the Act 1 and Act 2 is, my lord, that vesting of the land, my lord, before taking possession under the Act 2. And in the Act 1, my lord, it is, my lord, after, my lord, vesting, the possession would be taken. So my humble submission before lordship, my lord, service of section 3, my lord, is because in, my lord, under Act 2, I have no, my lord, right to raise any objection with regard to the, my lord, requisition or acquisition, which, my lord, has been given the, my lord, scope or opportunity in Act 1.
When vesting takes place under Act 2 of 48, at what stage?
In this case?
No, I'm asking you, under Act 2 of 48, when vesting takes place?
Vesting. My lord, after the gazette notification, my lord, after taking possession, issuance of the, my lord, section 3 notice, the above.
3 notice is vest. Show me.
No, section 4, gazette notification.
4.1a.
Gazette notification.
After that, it vests.
Yes.
So it's not at the requisition stage. It's at the acquisition stage when they decide, then notice has been issued, published, then it vests.
Well, subject to lawsuit after, my lord, taking possession under section 3, because when the, my lord,
it vests.
Not vest. Taking possession.
Taking possession, but it does not vest.
No, not vest.
Because at that point of time,
my lord,
the state is obliged to pay requisition compensation.
Well, that was the difference between the Act 1 and Act 2, which was, my lord, submitted before lawsuit.
Yes, you are right. But before paying compensation, it vests upon issuance of 4.1a, but it's the other way around in Act 1.
My lord.
But it's not at the requisition.
No.
It do not.
No. Only, my lord, taking possession. Only taking possession.
But at that point of time,
no vesting. No vesting.
Yes.
Well, after gazette notification, my lord.
Yes.
That is vested, my lord. So, my lord, in this, my lord, case, my lord, my humble submission before lordship, my lord, this statute is a special statute, and any deviation or breach, my lord, any of the, my lord, terms and
Anything more? Yes. Yes, Mr. Talukdar only replied to these judgments, nothing more.
My lord,
These two single bench.
yes,
I think this not the first one, the second two.
my lord, so far,
With-
First one is also, my lord, sorry, my lord, first one is also, my lord, that what is written.
does not say that. All right.
I will, my lord, just when I go through it.
none of this judgment I am disputing. My contention is elsewhere.
Here it has been held. It's binding upon me. It's binding upon me.
But
even if you say that the division bench did not expressly say so, but it considered this, even this coordinate bench is binding upon me. Direct decision on that point.
here,
Bound by
here,
this.
here, the issue directly, the two decisions cited, one Tarapnath
It
Sen
says
and other,
mandatory.
relying which Shoilendra's judgment was passed.
Yes.
My contention was that Shoilendra's judgment was passed, my lord, in ignorance of the law laid down by the Honorable Supreme Court. Because in May George, my lord may kindly remember,
79.
Yes. In Major's case,
what is the year? 79.
79. Go to the. I'm giving the citations.
Please see the year. If it is 79, then this no, Taraknath Sen was in 79. Please give the date.
that issue on the other day, it is 2010.
2010.
10.
No, so
2010 majors, and before that one more decision I relied, my lord, 1961.
Oh, 61. Yes, yes.
61. In majors, I have relied, my lord, paragraph number 14 to.
Did it take into this is not Act 2 of 48. This was how a provision is to be interpreted as directory or mandatory.
Yes, yes.
That is there, but here, even if by that this particular provision has been held to be mandatory, it's binding upon me.
Here in majors case, paragraph 14 to 25 I relied. Paragraph 16 to 24. So many.
This you are saying that how a provision is to be interpreted as mandatory or direct.
Position it.
But here it's a direct authority which says, even if your argument is it was wrong, I cannot go beyond that. It's binding upon me.
But
this
that was
is binding upon me.
My
even if you say no, the division bench did not go into that, make that observation, but relied upon this, even single bench and coordinate bench is binding upon me, which expressly says it's mandatory.
But if the law laid down by the Supreme Court is not taken care of.
Talukdar, what's the purpose of this?
Yes.
Because purpose
that is
purpose
what
is service. Purpose of service is to let the person know that
No.
yes, I am taking possession or I will be taking possession of your property.
Here.
So here it cannot be said to be direct. It has to be construed to be a mandatory because you are taking possession, it has serious civil consequences. You are taking possession, you are exercising your power to take possession of a property. Service has to be construed to be mandatory. Cannot be directory.
But
cannot be directory.
But here the proposition, the law laid down in these two cases, particularly I cited, my lord. This refers to some other cases discussed.
Because there is a distinction,
from
Mr. Talukdar, if a person, private person is to comply with that, is
Here-
one thing.
here one-
And when the state or the authority, certain duties cast upon that, those stand on different footings. Here, it's a duty cast upon the state to serve. Then in that event, that provision should be considered to be mandatory, not direct.
But here in none of these case, in 3 cases, it was not the directly matter in issue.
Maybe, but finding is.
So it was merely said in so many cases, my lord, on service of requisition order. If there is no, it is held in so many cases that if there is requisition order is not served, then the acquisition followed by requisition is bad. It is getting a.
No, but that is one way of looking at it. But your argument was mandatory or directory. These two decisions have directly held it's mandatory.
My lord, my submission would be, my lord, I followed. If you have.
And in one of the decisions, you said considering the object of the act.
My lord is not in my respectful submission. My lord is even not bound by this. Why may I explain? In none of these 3 cases cited by on behalf of the petitioner, the particular issue was framed. This section was taken into consideration. It was not. The issue was not framed.
This argument, yes, in one of the judgments, I think in Taraknath Sen, this was considered.
Taraknath Sen, 1993, paragraph 4 and 5, he relied.
4, 5, and 8. 4, 5, and 8.
Whether the principles laid down the purpose of what was discussed in 1961 in Hunukere's case.
Not in Taraknath Sen. Please kindly come to Bhinashar Finance.
1992.
1991, that 1992 1 CLJ.
Yes.
It was exhaustively dealt with.
Page 230.
230, page 230. It starts from the
next question whether.
Yes, from 229, this section 3.1 was considered. Mandatory requirement of the rule was that.
My lord is reading paragraph 7.
Paragraph
6.
6. Page 229.
Oh, 229.
Mandatory requirement of the rule was that such affixing of the order has to be made on the outer door of some conspicuous on the such and such is to be served ordinarily resides or carries on business such and such. Admittedly, the owner of the such, this is on facts of that case. 3.1 of the was not served. This is on facts in respect of the requisition order. Considering the scheme of the act, yes, considering the scheme of the act, the order of requisition 3.1 cannot be said to be valid and effective under the law unless it is served in the manner prescribed in the case of acquisition of land, language, other acquisition to be published in the Gazette, and that in that case there is a provision of affixing the notice of the premises when the legislature makes it clear, shall be served. So considering the scheme of the act, it has been held mandatory.
Page 230 are also stated. 230.
I'm at 230. Started at 229. Now I have reached 230. Considering this particular provision, considering the scheme, such provision is a mandatory, and that order under could only be effective only on service. So it was held to be mandatory, and it becomes effective only upon service.
Yes, here it is, my lord has rightly pointed out that court proceeded to hold that.
After considering the entire scheme, what is the effect? Also takes into consideration the Land Acquisition Act. There is a notification which is to be published. Because Mr. Talukdar, you are taking possession of a particular property. Now, that has serious civil consequences. We will say, yes, even if I do not serve, yes, possession is with me. I have taken possession. It's a directory. Even if I do not care to serve,
then my lord here,
it's in my possession.
Here, if we proceed, what has been held, this is a single bench decision.
So Talukdar,
My-
single bench decision is also binding upon.
Also, no, my lord,
And
may-
this was considered and relied upon, may not be,
Yeah,
while relying upon
when
and
this was considered in Shailendra's case,
division bench need not in so many terms say yes, again reiterate those.
yes, I'm not going into that issue, my lord. What I have tried to, my lord, submit, my lord,
Paragraph 17 টা দেখা
কার
2010
paragraph
17 টা Constitution Bank judgment 61 Supreme Court.
ও না কি দেখছেন?
ওই যে mandatory directive বলতে গেলে কি কি
Oh, that I submit. In Major's case, Lordship, for a moment, one page, if your Lordship kindly turns to. I relied on paragraph 14 to 25. My lord, I have not read few
What
paragraphs.
is the reference, Mr. Talukdar?
It is 2010-13 SCC, page 98. Major's case.
In yes,
Got it? My lord, I relied on paragraph 14 to 25. I have not read few paragraphs because they, my lord, refers to some cases. My lord, I think, my lord, it should be read. My lord, particularly paragraph 16 and 17. If your lordship kindly. "17 is a constitution bench judgment was considered. If the real intention of the legislature may consider.
'52 Supreme Court.
52 Supreme Court. So here 16, 17, 18, 19, so many cases, Lordship will find all our earlier cases right from 52. All those decisions were considered. None of these propositions, my lord, the principles settled by the settled principles of law were considered while passing this order. That was my humble submission. And in view of 1990, what I relied, my lord, that why it is
Mr. Bera,
1990.
Can you assist me?
Submission will be against me. Submission certainly.
He's the expert in the subject.
Formulate the point, I will try to assist you.
Because one issue is section 3.2
Yes.
of the Act 2 of
Yes.
3.1 and 3.2. This order of requisition has to be served.
Yes,
3.2
it's a
says.
mandatory. Tarapana's cases are there, other cases are there.
And the
those who are
rules are also there.
Yes.
Now there are two things. One, it says, the argument of Mr. Talukdar is coordinate bench. Mr. Chakraborty has cited some decisions. Division bench also, Shailendra's judgment is cited by saying that yes, it's mandatory because it uses the expression shall.
Yes.
So also takes into consideration the scheme of the statute.
Yes.
In one of the judgments, the 1992 one CHJ or CHM, that takes into consideration the scheme of the statute. But you know that there are a line of decisions while construing a provision to be directory or mandatory. How it should be. One is if any penal consequences are contemplated, then it should be mandatory. Other thing is there, if such provision casts a public duty,
Yes.
then it's directory. But if it is upon the private parties, it's mandatory. So here, though it uses the expression shall, it's a duty, public duty upon the authorities to serve. So if that view is taken, it should be construed to be directory and not mandatory. And what Mr. Talukdar was trying to submit is that, look, even if non-service of this notice, no penal consequence, it has not said that requisition will be bad or it is null and void, because there are several provisions: award not published within such and such time, that award, that proceedings go, proceedings lapse. So consequences are
there.
So they are here, according to him. Release from requisition is a different thing altogether. Release from requisition is valid requisition not followed by acquisition, then requisition. So it proceeds on validity of a requisition. Now we are at a stage before that, before section 6. So even if there is an irregularity, I think Mr. Talukdar also relied upon Indore Development's
Indore
judgment,
Development.
where it
Para
in
142.
one paragraph,
140. Which refers to
paragraph, it was said that irregularity in service does not vitiate this land acquisition
no.
proceedings.
Yes.
Irregularity.
Referring to Major's case.
Irregularity in service do not vitiate these proceedings. So this is also an interesting issue, and this will have a bearing, because there are some decisions, because coordinate bench has held, may not be as Mr. Chakraborty is, Mr. Talukdar is saying that these line of decisions were not considered, but it's binding upon me.
Let them serve me the copy, not copy, the list of cases they want to rely upon, Mr. All cases.
My lord,
learned friend, which
would your lordship bear me for a few minutes?
only this list of the cases they are relying upon. Point your lordship is saying, I understood. Let them serve me the list of the
Because
cases.
there are decisions this way, that way, and coordinate bank judgment, division bank judgment, holding, it's a mandatory. But
so far as Land Acquisition Act is concerned, provisions are not directly mandatory because penal consequences are there. Suppose Miller's 4 is published, 6 is not published within the time, then Miller goes. So it's a mandatory provision. Section 4 goes. Suppose Miller, the award is not declared within 2 years from the date of declaration, goes. All those provisions are mandatory. It has been clearly held by.
Those are mandatory. No dispute on that, because
but
if
here situation is completely slightly different. There no penal consequences in the, and there is no lapsing of the requisition proceeding. What is provided in the act? Lapsing of 4.1a notice
4.1a.
and 4.1a notice.
That is why he is saying that there is no penal consequences for non-service.
So far as requisition is concerned, plain reading of this, only 7 or 8 sections are there.
Yes.
Plain reading of that.
There is no penal consequences for non-service of this order of 3.1.
Order of 3.1. But in the
because if it is kept at that, no requisition, release from requisition, others are there, and if requisition you cannot continue after
those decisions are there,
those decisions are there after the act also, you cannot, you can convert, those are there. But what will happen that this, if it is not served, the statute will say yes, no, requisition goes. That is not there. So Mr. Talukdar is really harping on, even if there is irregularity in service, that does not vitiate the requisition.
Not requisition, but if we come to the conclusion, non-service of the section 3.1 notice makes the requisition bad. That is the penal consequence.
Acquisition of an achar.
There is
Where
no
is that provided?
There.
Where is that provided?
That provided. No,
that is
that
not
is the
been
decision.
provided.
That is the provided in the not provided. That has the decision of
the. You have to serve.
Decision of the court.
It's the decision of the court.
Decision of the court.
Now, Mr.
Yes,
Bera,
it is the
decision
decision of this court.
Yes, decision of this court.
That has to be looked into, because penal consequence is this: if the requisition does not subsist, then the government has no authority to continue possession of the land. These are the consequences. These are the consequences. Immediately they must return the land. Or so some penal consequences are there for non-service. Non-service makes the requisition bad. As soon as makes the requisition bad, then they have no right to occupy the land. This is the penal consequence. On what authority they will hold the land? On what? they must hold a valid order to hold or
No,
continue.
order is there.
Order is there,
Yes,
but
but
if the non-service
let us assume that there is irregularity in the service of
no,
law.
my lord, here I am joining this.
Saying
Whether this is a irregularity or regularity, that is to be looked into. Because I say,
no, those are all facts.
those are all facts.
Those are all facts.
My submission is this: if your lordship thinks in this way, their right to the property to continue with the possession, their right, how it, how it emanates from the statute, only on service of notice. That is the penal consequences. You cannot hold my property without a valid order of requisition, non-service. That is
Those
not.
I accept, but from the bare reading of the statute,
I look into that, your
bare
lordship.
reading of the statute, it does not follow.
Let them, serve me the
Yes,
copy
yes,
of the
because
cases. I look into that. I will
Well,
try to
kindly allow me to read 3-4 paragraphs of Major's case.
3-4,
George, I know.
Mr. Talukdar, yes,
Yes.
these are well settled. Proposition, it's settled that generally speaking, the provisions of statute creating public duties are directory.
Yes,
So by
yes.
considering this, it is to be held.
No,
So the
two more,
provisions
two more. Lordship, kindly allow me a few minutes. My lord has seen the constitution bench also. I am not troubling your lordship. The 17 para 17 refers
Yes.
to a constitution bench judgment. Then 18 onwards, my lord, 3 paragraphs I will be reading. In so and so cases, this court
intent of the lawmaker. Yes, all these.
This provision is mandatory or
There are
directive.
3-4 tests to
The
be
consequence
be
and shall.
applied before holding whether it's mandatory or direct.
No, why I, my lord, want to read this? Shall and the consequence part is dealt in this paragraphs. My lord, kindly allow me.
This has to be applied to this act. It has to be, these are settled propositions.
Shall.
Will also not, nobody can dispute this.
General difference is this: provisions of acts are generally mandatory and rules
This
are
is
directed.
also on land acquisition.
Rules
Mr.
are
Mr.
rules
Bera,
framed
this
are
is also on
directed.
land acquisition. This decision is also on land acquisition. May George.
Major. I will look into that. I will look.
It is also on land acquisition.
Yes.
Not other decisions.
Lord,
18, 19, and 20. Kindly have a look. My lord will get the answer. If specific consequence is not provided.
You have an extra copy of this judgment.
Yes, I can provide this.
Please.
18, 19, and 20. Lordship, kindly. 17 I have already indicated. 16 onwards, relying on all these cases.
17, 18, 19. 17, 18,
17, 18 এখন বললাম আমি 14 to 25 I am relying. 20 also says that specific consequence should be there, and the shall word, using the shall word, 20 deals with. This shall, my lord knows, in some judgments held that shall sometimes considered
Generally
as may.
speaking, shall is mandatory.
Yes.
And may is directory.
But
yes, in some cases shall may be
construed as
to be
may.
directory,
As may.
may as mandatory.
May as mandatory. It happens. It depends on the intent of the legislature.
Paragraph 25, Mr. Bera, if you come to.
Major.
Yes, May George.
25 summarize the.
Yes, it summarizes. Law on this issue can be summarized to the effect that in order to declare a provision mandatory, the test to be applied is as to whether non-compliance with the provisions could render the entire proceedings invalid or not. Whether the provision is mandatory or directory depends upon the intent of the legislation and not upon the language for which the intent is clothed. The issue is to be examined having regard to the context, subject matter and object of the statutory provision in question. The court may find out as to what would be the consequences which would follow from construing it in one way or the other, and as to whether the statute provides for a contingency of the non-compliance with the provisions, and as to whether the non-compliance is visited with by small penalty or serious consequences would flow therefrom, as to whether a particular interpretation would defeat or frustrate the legislation, and if the provision is mandatory, the act done in breach thereof will be invalid.
So,
I understand. Consequences from the statute itself, it is to be seen.
Very first sentence.
Yes.
The law on this issue can be summarized to the effect that in order to declare a provision mandatory, the test is to be applied as to whether non-compliance with the provisions could render the entire proceedings invalid. If I apply this test so far as 3.1 is concerned, if 3.1 is not served, there is nothing, no valid order of requisition. Requisition goes. As requisition, if requisition goes, their possessions become arbitrary or
Mr.
nil.
Bera, the statute do not say so. Because
Statute do not say
because
so.
it is
Only-
clarified. Please see this.
Yes, your
It
lordship
is to be examined. No, here it has been clarified. Please see nearing the middle of that paragraph. The issue is to be examined having regard to the context, subject matter, object of the statutory provisions in question. The court may find out as to what would be the consequences which would follow from construing in one way or the other as to whether the statute provides for a contingency. So the statute is to provide a contingency. It should not be implied. So statute likewise in section 7A or 11A.
7A.
So it says within 2 years it is to be done, otherwise it will lapse. So that's the contingency under the statute.
So no, yes, I understand, but only in one section, if we want to test the provisions of a statute of a single statute, whether it is directed or mandatory, subsequent sections or previous sections have to be looked into.
Yes, yes. Entire act.
Entire act to be
Yes, yes.
entire act to be looked into.
Yes, because the object of the act is to be looked into.
So far as this object of the act is related, so far as 11A is concerned, when notification was published, when declaration was published, and penal consequences are there. So far as section 3 is concerned, it does not say in terms that for non-service it will be rendered invalid. Entire this section say, but the court interpreted it to be that it must be done. If
He's
it is
challenging that interpretation.
challenging,
Taking
how, but in that case, your lordships have to look onto those lines of cases where, my lord, a decision, even if a high court, even if it is single judgment, it is, my lord, remains valid for years together. That cannot be touched. That your lordship knows so many cases. Your lordships knows much better than me. Gaur Gopal Mitra's case 67 CWA. Supreme Court, even in 2002, did not touch. So interpretation of this court subsists. My lord, that cannot be touched. In those lines,
Mr.
lines
Bera,
are
I tell you,
there.
I give you one instance in preemption.
Yes.
In preemption matter, starting from 78 Calcutta, it was all throughout the view that shortfall of the consideration money cannot, the preemption application cannot be dismissed. It can be directed. It has been reversed in Barasat Eye Hospital in 2009. Long-standing practice. All along, this was the precedent.
Those lines of decisions are.
So either way, this is
Either
there.
way,
So it has been held no.
So far as your lordship's observation is
all decisions
no
on that
penal
line.
consequences provided in section 3.
That is one way of looking at it. Yes, you are right, because that's also one of the views. Because this is the long-standing view.
There, because your lordships has considered this scope of section 3 in one cases where I argue before your lordships. Then in requisition notice they say that I am taking this possession, ultimately taking possession of this land.
The balance, the smaller amount.
Smaller amount, but your lordships kindly have me chance to look into this.
Yes, yes, because this is an issue. It has to be, because some decisions are there, and it's also an issue directly will have some bearing, this way or that way.
Yes, the lordship. Let them supply me the copy of the list of the cases, not the cases. If better, they can serve the copy of the decisions, no problem.
Yes.
It will
Mr. Mukherjee, since you are representing the state, it's an acquisition matter, and this interpretation will also have some bearing. So please make yourself also ready.
Because 1990 volume 3 will apply.
Because,
If my
please, both of you, don't cite decisions on other issues.
Yes.
Only on
this issue.
Only on this issue.
Section 3
Don't burden Mr. Bera on other issues.
But whether
Only
section 3 is directed or mandatory, only they should be.
this 3-2.
Yes.
3-1 order, service 3-2 and rule 3 of the rules.
And also to consider, if this particular issue is not considered by the honorable single bench or division bench in earlier cases, whether in this principle laid down in Major's case and Hunuker's case 1961, that par incuriam will
Now
that
he says,
1993.
from 52, if that decision is prevailing, not considered in any of the judgments.
What will happen, the consequence?
No problem.
Par incuriam, all along this view, single bench, division bench also.
And
What
there
is
is no
all-
issue before the
whether-
decision made.
Whether the special bench also that that matter 3-2 and this 9-3A, 9-3B.
Oh, that is
special-
Bhaskar Bhattacharya judge. There I appear.
What is the name?
Sobita
Sobita Mondo. Sobita Mondo. So I do not know.
There
3-2
these issues are not there.
3-2 was not there. Please check up that also. Please once check up whether, because this Requisition Act and Land Acquisition Act, all provisions were
My
considered.
knowledge goes, I direct.
No, Sobita Kundal, that was not the issue.
Please also look into that, because if one stray observation is there,
Yes, yes.
Mr. Please check up, because
I'll check
faint
up. I-
recollection
I-
is that this
I-
was not the
I-
issue.
My lord, this issue, I remember, my lord, for many years, my lord, I am defending cases. My learned senior friend also knows that this issue never came up. This issue never came up in the cases, my lord. I had the occasion to appear.
It's better to refer it to the larger bench. I think it's better to refer it to the larger bench. Let the larger bench decide.
Whether it has not been.
No,
considered
mandatory
by-
issue was not.
Mandatory was issue.
That was not.
That is Mr. Taluk. That is one of his argument, that in none of the matters this issue was raised.
Particularly.
So,
It must be framed by the court.
but in some matters,
First of all, your lordship try to resolve the dispute. If it is not necessary, if it is necessary to refer to larger bench, I think it will not be necessary. Your lordship will decide that. Let them have these copies of the application.
I shall supply. One factual correction is necessary, because my learned friend referring to page 64. He was
Mr.
making
Taluk, that
submission.
factual reference.
No. This factual correction is necessary because he is challenging. There were two phases of acquisition.
That factual part we can consider later.
Yes, he
Factual
is
part
wrong in
is,
indicating that.
because this is the issue. Because if you succeed, if you fall on this, then you have a difficulty. But if you succeed on this, maybe a different thing.
If I fail on this issue, I have another other issues.
After the
There-
after the published-
Plain reading, my lord. Consequence will be serious if it is held to be directory. I can tell you, lordship.
That
If
I
it is held to
understand,
be
Mr.
directory, consequence will be serious. Government
Sir,
will go on.
Sir
continue
Bera,
to-
I understand that. That is why, and
Yes,
that is one aspect.
yes.
And two is that there are some decisions
Yes.
may or may not have considered what's the effect, but holding it to be mandatory. Second. Third is that it has serious civil consequences, because what is the effect of this? Effect of this, I'm taking your property. So I must make you aware
Yes.
that I'm taking possession of your property.
To whom? The
His
person concerned.
That is what I'm saying. I'm saying I want to take
The
Mr. Bera's
landowner,
property.
landowner or occupier.
Yes, I want to take Mr. Bera's property. So I have to inform him. So the purpose of serving the order is only that. He
Only
must
that.
only he has to know that his property is being taken possession of under what authority.
Under what authority?
So
Only
that's
to that.
yes.
Even your lordship, so the other lines of decision are there, that landowner has no right to object such acquisition.
Yes, those are other things. What is the
Other
effect of
thing.
that? That is the other thing.
So whether I must be served or not, that is which also.
Yes, because some effect, because his
some
possession
effect
is going,
going,
and even if he without serving,
Without
his
serving.
property will go.
Here,
Maybe he may not have any right to defend, may not have any or very little scope to challenge. All things may be
So many provisions for serving of notice under the norm in saying other cases, but in the land acquisition cases and in Act 2 or the so far as the Section 3 is concerned, all those there are several provisions of service of notice. What are the consequences of that? In some cases, service of notice is not mandatory, but in some cases it may be mandatory. That is to be looked into. I understand your lordship's point, Milord. I will try to assist your lordship.
Uh, কি হেডিং এ আছে?
My lord, I am appearing on behalf of state, my lord.
You are appearing on behalf of the state.
My lord.
কে
In
বলছে?
item number 22, my lord.
No, not 22. আচ্ছা, এটা not forwarders. I am keeping it as motion because forwarders I thought that as
What
motion.
your lordship fixed the time and date, no problem.
PM করে
Under
দেন।
what it is.
Kindly make it part.
Why?
They are for their financial benefit.
Yes, yes, next.
My lord, item number A, that is monthly list 59 was taken, my lord. I was just A59 earlier, before this.
Yes,
matter.
yes, you are not
My lord,
present.
private respondent, we got a call at 1 o'clock, my lord. Just a call, no notice was there. Even the copy that was served by the post, that weighed out only 20 grams, 133 pages. It did not give out the entire documents. to
Please
us.
ask your learned friend. Please bring him because ask him to come. Mr. Mukherjee, you appeared.
Yes.
Can you ask your
59?
junior to stay here because if the other side comes. If you have any other in area code, please ask
Just
your
I'm
junior.
coming.
Please ask the
Yes, yes.
petitioner to come.
Just-
Yes. Call the next matter.
Item number 22.
22, my lord, I am going to the petition.
Yes.
But yesterday, your lordship has been directed that as to why the letter has not been complied with, my lord, I have already communicated upon the, my lord, landed LR, my lord, DM, district magistrate LR. Now, these records is, my lord, which has been appeared in the report as
You have,
filed by
you have submitted these documents.
Yes, I have already submitted
Yes.
the document on Thursday.
Lordship, I don't have any
27.
copy. I don't have a copy. May I have a copy?
Give a copy to him.
How he has been
My lord, up to 25th, day before
record
yesterday,
date
this
of
was not submitted before us, my lord.
25th and 25th, my lord, after that 27th, I was, my lord, on message that you have to submit these documents. Now, how can I?
No, no, you have submitted now. Please
Yes.
give a copy to him
On
now.
20, my lord, I have already given.
Give a copy. Let him take instructions.
Yeah, একটা copy দিতে হবে। My lord,
One
in
more
view-
copy. AGP is appearing in this.
হ্যাঁ, ঠিক আছে। My lord, in view of this, my lord, the report, is it, my lord, I gone through that there is no nothing because the old records, they are not, my lord, availing of all the records. Number one. Number two, as it appear in the report, that, my lord, 1984, the allotment was made in favor of the petitioner's father. Now, the petitioner died in 2020. Now, soon after died, the railway authority has been taken over possession. Even 85, a writ petition was filed. 85 writ petitions was an interim order. That interim order, my lord, we do not know, no service, not made a party. Ultimately, in, my lord, 2005, this writ petition was, my lord, referred to the tribunal for final disposal. Ultimately, nobody appeared and matter was dismissed for default. Now, entire interim order as well as the, my lord, the cause of actions has been gone.
It's 26.
Now, yes.
My lord, from
My lord, let me
2000 to
submit, my lord, then-
2005 petitioner was sitting.
How the railway authority did not appear? How the state will submit it? I'm surprising because the state of
Interim injunction
railway
was
authority is the
vacated,
made
but
party.
the
I
petitioner
have already
did not
served the
come
copy.
to me, come forward to
service.
claim
How
his
the
claim,
state will submit?
to make his claim, my lord. And today, and after 20 years, he is coming.
Report has been, my lord,
Basically,
affirmed
my
on
lord,
25th.
this writ application is time barred, my lord, and not maintainable in the eye of law.
What I am why you are saying that in report that make an application, liberty is to be given regarding the renewal, regarding the continuous, because lifetime deposit has been 10,860 at the material point of time. Now in the meantime taken over possession. They did not produce the record.
Where is the offer of allotment?
Offer of allotment letter, my lord, kindly see the page, my lord, in the writ petition, page 15. 28/5/1984.
Yes. Did you get possession?
Yes, I will have taken boundary. within the blood 0.05
My lord, there is no possession letter inside the writ application, my lord. Only the
Yes, my
allot-
lord,
whatever
it has
amount
been
he has
appeared on
submitted, that is deposited,
22nd,
that
and
is
next page is
clear, my
16.
lord.
My lord, kindly see, with reference to his application dated June 1983 for allotment of a lease of land out of XKF railway land, this is to inform him that a piece of land measuring about 0.05 acres in Moja such and such, plot number
Now what do you
15 under
want?
PS Behala.
What do you want now?
My lord, I am praying, my lord, before your lordships, that, my lord, the petitioner, they have also made an affidavit for the legal heir successors, all the documents, and that, my lord, liberty is given to the petitioners to make an application to the authority for renewal or to continue this position, but in the meaning to vacate the, my lord, land of the position, because the railway authority has no power, since it has already been lifetime deposited by the by the deceased father. Only 2 daughters are there.
Only 1 year amount,
Married daughters.
rent amount
They
is
did not know
deposited,
about
my
this
lord,
facts and
only for the
circumstances of
year
this
of
case regarding the
84 to
tribunal,
85.
regarding the High Court. So after
Not
this,
a
they have
civil
taken
report
possession.
he has,
This
amount he
possession
has
is totally
Allotment
illegal.
was made,
85 onwards, my lord.
but a lease deed
Neither I
was to
have
be
given the
executed.
possession letter to
Executed.
him.
Show me the execution of the lease
Deed
deed.
of deed of convenience, I will also prayed for in the affidavit. I
What
have already
affidavit?
given that.
No, this allotment was made in 1984.
84.
Show me the lease deed.
It has been an order passed. Order passed, no lease deed. I was prayed for. I was prayed for the deed of convenience to be made.
In this writ petition,
In this
in
writ petition,
2025, allotment made in 1984.
84. My lord, I'm saying, my lord, I am saying,
Part.
my lord, I am
What
saying.
were you doing from 1984
Kindly,
to
kindly see
2025?
the report. Kindly see the report. I am saying, my lord, I'm reading this report.
Yes.
My lord, only 1 second, because the state has already been submitted.
What are the conditions of this allotment? How much amount you have to pay?
No, my lord, it is been
Monthly, yearly, what is the conditions
no,
of
nothing about contention was
this?
there.
You will be enjoying by
No.
paying 10,884.
No,
You mean to
no,
say
my lord,
that?
not at the material point of time.
Yes.
My lord, because 10th,
What are the terms and conditions of this allotment? Please show me.
1076 per year.
Please show me the possession certificate. Please show me.
My lord, this is the letter.
What?
Except page 15. My lord, you also kindly see.
Yes.
Road treasury
My
challenge.
lord, that is
it has
the
already been paid.
allotment
Show me
letter,
the
not the
possession letter.
possession
This is not the
certificate.
possession letter.
My lord,
This is the
kindly see the letter.
My lord.
Yes.
Well, at 7 June 1984, and delivery of possession of the holding will be made in favor of the
This
petitioner.
is intimating you.
Subject.
This is not the possession letter. Please show me the possession certificate.
My lord, kindly see the.
Please produce the possession certificate.
My lord, kindly see. Kindly the next page. Page
Yes.
16.
Yes.
Letter dated 1984.
Yes.
My lord, with reference to his application dated such and such for allotment of a piece of land.
Tentatively allotted.
Allotted.
Not possession.
Yes.
Please show me the possession certificate, sir.
My lord, page 16 is the proposal for allotment of land.
8th August 1984 at 11:30 a.m.
Show me the possession certificate.
My lord, possession certificate will be, my lord, if any record, my lord, is available, your lordship kindly, my lord, kindly see, and my lord, kindly see the execution of the report. My lord, this is very, my lord, totally illegally and arbitrarily by the railway authority. This is my property. That property cannot be taken. My lord, 4 weeks, my lord, opposition, and 2 weeks, my lord, reply.
Yes, call the next matter.
No interim order at this stage.
Deeply obliged, my lord.
Since the petitioner could
My lord, I have called upon the phone also. He did not pick up the phone. The clerk was informed. He said out he's not picking my phone. Even the person has been sent to the room number 13 also. He's not there, my lord.
Then what
Can
be
it be
done?
kept out, my lord? It can be recalled and kept out tomorrow, my lord, or day after.
Recall in his absence
My
cannot
lord,
be. In the presence of the parties, he said he's informed you.
my lord, that is altogether.
be
My lord,
done?
I can give her the phone.
I've directed only the authorities to take steps. 10-1 notice has been served upon you.
But my lord, this is a
Contest the proceedings there. 10-3 I've directed to complete the proceedings. You can appear there. Or if you want, you have to file an application. If he comes, I can recall. Otherwise, in his absence, I cannot recall. Yes, call the next matter. Yes.
Where the fixed matter will go on, will it?
Subject to where are the advocates?
Mr. Bose
Yes,
is here.
Mr. Bose can tell you how much you.
Mr.
Oh,
Bose is saying
where
it
is
depending
Mr.
upon the Mr. Chaturvedi.
Where are they? Yes. 95 এর এইগুলো দিন পেপার please make some submissions till
But
they
in
reach.
the other matter are released, will it?
You are in Mr. Bose's hands.
Of course. Chali daw nahi.
I think they should wait for 5 minutes and then they shall be, once the matter starts, we'll be in a better position to.
Yes, yes. Now Mr. Banerjee has come. পেপার বুকটা আর এইগুলো হ্যাঁ Mr. Banerjee, please start. Don't pray for Passover. If other matters are taken up. Yes, yes. Please start. Please start. Yes, now Mr. Chaturvedi has also. Mr. Chaturvedi will take 1 hour. Rest of the day.
Other matter. But other matter.
বলে দিন accepting this এটাকে রিলিজ করে দেবেন না Yes, yes, Mr. Chaturvedi.
Lord, before Mr. Chaturvedi starts, but we have come across one more judgment, Supreme Court judgment, which will be very relevant on the issue which is in. Lord, kindly take this. This is 1962, AIR 1963, Supreme Court 243.
For what proposition, Mr. Bose?
For the proposition that firm, if there's a decree against the firm, what would be the consequence? Well, kindly first take the facts your lordship will be able to ascertain from paragraph 2 of the judgment. A copy.
Paragraph?
Para 2 are the facts. There your lordship will find. There was a decree against the firm.
Yes.
So then the issue arose. This was also one of the queries that fell from your lordship in course of our submissions, that what will happen to the decree that you've obtained? Well, the answer is here, my lord. Order 21, Rule 50 appears to be the answer. My lord, kindly take paragraph 4.
Yes.
Supreme Court refers to Order 21, Rule 50. Sets it out. And then, my lord, paragraph 5. This rule deals with the execution of decrees obtained against firms. It enables the decree to be executed against the partnership assets. It also enables that the decree may be executed against anyone who appeared in the suit and admitted that he was a partner or who was lawfully adjudged in the suit to be one. It also enables the decree may be executed against any person lawfully summoned in the suit as a partner, but who did not choose to appear individually or defend the action. Lastly, it provides that if it is desired to execute the decree against a person as being a partner of the firm who does not belong to the categories already mentioned, then the leave of the court.
Leave is to be obtained.
Correct. Then it continues. Then, my lord, kindly a sentence
then
thereafter.
If it is taken up, Mr. Bose.
Yes, my lord.
On the facts of this case, let us assume for the moment that the appeal is dismissed. Decree remains.
Right.
but no one is there to represent.
Yes.
Because there is no partner according to you left.
Yes.
So in view of this paragraph 5,
Yes.
you can execute this decree against Mr. Chaturvedi's clients.
No, I will execute it against the property.
Against, please see, it
Yes.
also enables that
Yes.
the decree may be executed against anyone who appeared in the suit and admitted that he was a partner.
Correct.
So admission of that person as a partner, so you can execute against them. So you can execute the decree as against Mr. Chaturvedi's client.
Yes.
But whether he has a right to proceed with the appeal is a different thing altogether.
Absolutely.
But your right to execute is protected under paragraph 5.
Yes. Now, I will also kindly also take a note of paragraph 8.
8, yes.
Well, this after analysis of the different rules of Order 20, then, my lord, from the above analysis, it is clear that a plaintiff needs sue only the firm. But if he wants to bind the partners individually, he must serve them personally, for which purpose he can get a discovery of the names of the partners of the firm.
Order 30 Rule 1.
Correct.
So if your intention is to, the plaintiff's intention is to bind the partners along with the firm, then you have to comply with Order 30 Rule 1.
And I have to name the partners. Or now I have chosen to file the suit against the firm. Then, my lord, kindly see the next sentence, kindly.
Yes.
Persons served individually may appear and file written statement, but the proceeding go on against the firm only. They may, however, appear and plead that they are not partners or were not partners when the cause of action arose, but even if no other partner appears, there may be a decree against the firm if the firm has been served with the summons. The gist of Order 30 thus is that the action proceed against the firm, and the defense to the action by persons admitting that they are partners is on behalf of the firm. Persons sued as partners may, however, appear and seek to establish that they are not partners or were not partners when the cause of action arose. But if they raise this special plea, they cannot defend the firm. This was laid down in connection with the analogous provision of the English rule in Weir versus McVeigh. Then partners appearing and admitting this position as partners can only defend the firm, because the suit continues in the firm's name. The law is thus not concerned with a fight against the partners inter se, and an action between the partners is not to be tried within the action between the firm and the plaintiff. Of course, the partners who admit that they are partners need not raise a common defense. They may raise inconsistent defenses. Then, my lord, it continues. All such defenses must be directed to defend the firm.
So according to you, it can be executed against the assets of the partner.
Yes, yes. My lord, kindly also take one more paragraph. My lord, kindly just bear with me, my lord. Then it says, must surmount to all defense. Then Ellis versus that same paragraph on the next page, page 6 on the top. Then, my lord, Ellis versus Waitson, which is all along been considered. The purport of the rules as well as the two English cases, which have correctly analyzed the rules on the subject, the English and the Indian rules being alike, is that the partnership is sued as a partnership. And though the partners may put in separate defenses, these defenses must be on behalf of the firm. If some of the partners do not appear, those that do must defend the firm. But if no proper defense is raised by them, the plaintiff cannot be deprived of a judgment. The judgment and decree thus obtained are executable against the partnership assets. This brings the provisions of Order 21, Rule 15. Now take, my lord, para 9. The rule enables a decree obtained against a partnership firm to be executed against the property of the partnership. Next, it enables the decree to be executed individually against a person who appeared in his own name under Rule 6 or Rule 7 of Order 30, or who admitted on the record or was adjudged to be a partner. Next, the decree can be executed against any person who is served individually as a partner but has failed to appear. Next, it permits the decree to be executed with the leave of the court against the same thing.
Yes.
Grateful.
Yes, Mr. Secretary.
I suppose that at a juncture when my existence is in crisis,
Your existence is in crisis.
but the scope of the objection raised by Mr. Bose, my lord, has enlarged in course of deliberations. My lord, on 17th of November, I remind myself that my lord was hearing the appeal on its merits. Lord, the matter was fixed next on the 18th of November. Lord, Mr. Bose came up and sprung a surprise that on 18th November, they saw a photograph which was clicked sometimes in 2021, and from that it transpires that the other surviving partner, according to him, of the
Passed away
firm
long back.
has passed away in 2021, and hence the appeal has abated. Application will not comes. So today we are confronted with the sole issue as to whether the appeal has abated or not. Now, in course of deliberations, in view of the fact that Mr. Bose made a submission that on the death of the first partner, they are under no obligation to take any steps. But on the death of the second partner,
you are obliged to take steps.
I am obliged to take steps. By natural corollary, my lord, it struck all of us as to whether in that event the suit also abated.
That
it struck us. It struck us. So, my lord, we, with my lord's magnanimity, my lord, we deliberated on that as well. Lord, now with the submissions that Mr. Bose has made, Lord, we have covered a distance possibly we were not required to. The effect of a partner dying during the pendency of a proceeding where the suit is won under Order 30, Rule 1.
Firm. Against the firm.
Against the firm. And I confine myself only to meeting, my lord, the objection of abatement without today making any attempt to, my lord, go into as to whether the suit abated or not. Today, I shall only confine myself to it. Because, my lord, if my appeal, it survives, then that decrees and nullity I can, my lord, argue in the appeal when I argue before my lord, I can take up even in section 47.
Yes.
So today I confine myself not only to whether I have been under any lethargy or any indolence of not having taken any steps which I was obligated to take, and yet I did not, thereby resulting in abatement. But for that we need not only confine ourselves to what Order 30 Rule 4 says, and a conjoint reading of Order 30 Rule 4 and Section 42 of the Partnership Act. But I have come prepared with some judgments on Order 30 Rule 4. I shall come to that. But we are today posed with a situation that admittedly the suit is not filed under Order 30 Rule 1. And one partner died
Pendency of the suit.
During the pendency of the suit, and that the appeal filed thereafter, the first appeal and the second appeal, were all maintainable despite the death of the first partner, is an admitted position.
Yes.
Both
At the
parties.
stage of till the stage of filing of the second appeal.
Well, then I take it that till the date, till the filing of the second appeal. Now, Milord, the second appeal comes. Before the second, now the second appeal comes. In the second appeal,
the other partner died.
Before the death. Milord, the firm was reconstituted. The reconstitution is a firm, my lord knows that section 42 of the Partnership Act, my lord, it provides for a dissolution of the partnership firm under 42C. But the commencing lines of section 42 is says subject, however, to any contract to the contrary. That there existed a contract to the contrary is an admission, my lord, which I have indicated to my lord. But this admission, my lord, I need not prove any further, because today what I am, my lord, only, my lord, obligated to show to my lord is that the firm existed notwithstanding the death of the first partner. I'm sorry.
Give me 1 minute. Yes.
Yes, my lord, we were not being
That matter, so I'm keeping it tomorrow as item number 1, because he has come. Item number 59. Item. Yes. Yes, Mr. Katul.
And my lord, these reconstitutions were to their knowledge, my lord, I had shown when, my lord, I was addressing my lords, my lord, lastly. My lord, what was to their knowledge? My lord, I only recapitulate. But it was to their knowledge that one partner died. It came to their knowledge, my lord, in the evidence of the other partner, PW1. My lord, that the firm was reconstituted with induction of 2 new partners, and thereafter retirement of the second partner is also to their knowledge. The retirement of the partner who died in 2021 is to their knowledge. Lord, have I been able to make
from the contempt application?
From the contempt application, and also from the notice that, my lord, is sent in reply on behalf of the plaintiffs. So if the plaintiff respondent is aware about the reconstitutions and about the continuity of the stature of the firm, and it sues the firm for enhancement of occupational charges, Lord, today, Lord, does it lie in the mouth of the plaintiff that now that you have not been able to implement a coercive measure of enhancement of occupational charges, that you take up a plea of abatement, saying that all said and done, we now fall back upon the theory that we have sued 2 partners. I'm sorry.
Yes.
We have sued 2 partners who were carrying on the firm in the trade name. But the suit for all material purpose was in the name of 2 persons. First died during the pendency of the suit, second died in 2021. There is no one to take up the cudgels on behalf of the firm, so the appeal abates. When you were aware in 2013, while you filed the contempt application, that it has been reconstituted, that gave you the courage to sue the tenant for enhancement of occupational charges. When you are unsuccessful in that, now today you, instead of meeting the appeal on its merits. Today you take up the technical point of abatement. I said, does it lie in your mouth? You yourself you have acquiesced that. That was a stage when you should have said that the appeal has abated. But you chose to sue the tenant for enhancement of occupational charges.
Yes.
Lord, kindly, Lord, for a moment, Lord, takes up Order 30, Rule 4, Lord, for my satisfaction.
Order 30, Rule 4.
My Lord. Lord, my obligation under law, if any, will flow from here.
Yes.
Lord, kindly sees that, Lord, this applies in respect of, Lord, all suits, Lord, which are filed under Rule 1. Notwithstanding anything contained in Section 45 of the Indian Contract Act, where two or more persons may sue or be sued in the name of a firm under the foregoing provisions, and any of such person dies, whether before institution or during the pendency of any suit, it shall not be necessary to join the legal representatives of the deceased as a party to the suit. Now I put a poser to myself. This is a provision which would apply mutatis mutandis even to the appeal. In view of whatever is contained in sub-rule 1, do I have an obligation? I would mean, Lord, the second partner, according to them, was he under any obligation to take any steps? On the death of the second partner, was the reconstituted firm or its partner were under any obligation to take any steps? Where did I falter to be confronted before my Lord, to be posed with a threat that your appeal does not exist anymore? Where did I falter? What should I have done? Where is the provision in law? Lord, I would have understood if the suit was filed, Lord, in the name of individuals, depicting them to be partners of an unregistered firm.
Such and such carrying on business.
Lord, I would
partnership with such and such under the trade name.
Lord, I would say, I'm grateful, my Lord. I would have not considered that by some stretch we could have invoked Order 22. But in this case, Lord, I do not have any right, and I shall cite judgment, my Lord. The Honorable Supreme Court has said that if you do not have a right this way, you can't even invoke Order 1, Rule 10.
Yes.
Now, my Lord, kindly sees, my Lord, Order 30, Rule 4, Sub-Rule 2.
Yes.
Nothing in this Sub-Rule 1 shall limit or otherwise affect any right which the legal representative of the deceased may have. So this talks about the rights of the legal representative. But admittedly,
have a right to apply.
Now the legal representatives are nowhere to be seen, are not before my Lord. But this is only to preserve the right of the legal representative in a situation where the deceased partner had, my Lord, invested his fortune in the partnership firm and he suddenly left for the heavenly abode. My Lord, he has, my Lord, a right in the goodwill.
So basically gives the right to the legal representatives to protect their interest so far as their predecessor is concerned.
Right. As also
vis-a-vis the partnership firm.
Right. As also to be sued in the event if the deceased partner had a liability. This is not to apply to be made a party to the suit or to enforce any claim against a survivor or survivors. So it is a right to sue and be sued both.
Yes.
So we are, Milord, not in any way connected, Milord, or concerned with sub-rule 2.
According to you, sub-rule 2 will come into play when the legal representatives come.
Yes.
It's not a case here.
My lord. But we are confined only to, Milord, Order 30, Rule 4, Sub-Rule 1. And I say that if the admitted position is that the suit was under Rule 1, I said Rule 4 comes to my rescue. I was under no obligation to do anything. And reconstitution was to your knowledge. You have decided to continue with the list against the reconstituted firm. Today, I would say you call it an abatement by citing the death of a partner, retired partner. It is to your knowledge that he is a retired partner. Now, retired partner died, you say that the suit has abated. Why? Because he was the original, he was a partner when the suit was instituted. Not under what law, I put this question to myself. Not one decision.
Yes, Mr. Bose.
But this is 1984. 1984, Volume 3, Supreme Court Cases, page 462. Lord, this is a very short judgment. Kindly permit me, Lord, to place the facts. The respondent Balakrishnan filed original suit number so-and-so in the court of second so-and-so against a firm styled as so-and-so and its partners constituting the firm at the relevant time for eviction from the premises occupied by the firm as a tenant. So, my lord, here, my lord, identically, the firm was a tenant. Partners were, my lord, additionally, my lord, implicated as party. The Supreme Court, my lord, later says that their addition was only formal in nature. By the firm as a ground on the ground that the tenant has impaired the value and utility of the demised premises. The suit was registered by the defendant's present appellants. The suit for eviction was dismissed by the trial court. The respondent landlord preferred civil appeal number so-and-so in the court. The appeal of the landlord succeeded and a decree for eviction was made. There was also a decree for mean profits and cost. The firm and the partners filed second appeal in the High Court so-and-so. When appeal was pending, two of the partners so-and-so and so-and-so died. This fact came to the notice of the High Court. When the appeal was taken up for hearing, the High Court posed to itself the only question whether the appeal abated because the heirs and legal representatives of the two deceased partners were not substituted within the prescribed period of limitation. It may as well be mentioned that an application for bringing the heirs and legal representatives of the deceased partners was admittedly never moved. The High Court held that as a suit was instituted against the firm and its partners, and as the first appellate court has decreed the suit against both of them, the decree of eviction against the two of the deceased partner has become final, and in order to avoid conflicting decrees being passed in respect of the same cause of action, the appeal abated as a whole. It is this part of the order and the judgment of the High Court which is questioned in this appeal. In the plaint para 1, the following averments are made. Then the averments that the defendant firm was in occupation of the property. We'll kindly skip over. Then the tenancy commenced. Though the defendant Ramnarayan usually dealt with the plaintiff on behalf of the firm, but it is claimed by the defendants that they are partners of the firm. Hence, they are also implicated as proper parties to avoid controversy. This averment was not...
Paragraph 11 is the answer.
My lord.
Yes, next.
যেগুলো দেখছিলাম ওইগুলো কই গেল? Yes. Lord, next, Lord, I rely, Lord, on a full bench decision of the Punjab and Haryana High Court. Lord, this is AIR 1966. Punjab and Haryana, page 40, full bench. To Devin, please. To Devin, Joshua, okay?
Yeah,
Lord, kindly sees,
Yes.
but the second page, the second paragraph, in order to appreciate the point which we are called upon to decide, the relevant facts may briefly be stated. I must first, my lord, seek an apology. This is the copy which I have handed over to my lord. My lord, is not extracted from the official website, I understand. The relevant facts may briefly be stated. Mrs. Kishan Chand Hari Chand, metal merchants at so-and-so had instituted a suit out of which this second appeal arises for recovery of so-and-so. This suit was dismissed by the trial court, but on appeal, the judgment and decree of the court of first instance were reversed, and the plaintiff firm was granted a decree for recovery of so-and-so with proportionate costs throughout against the defendants by the learned senior so-and-so. The present regular second appeal was presented in this court in so-and-so, and at the hearing before the learned single judge, an objection was raised on behalf of the respondent firm that so-and-so has died and his legal representatives having not been implemented within the prescribed period of limitation, the appeal must be considered to have abated. This objection was met on behalf of the appellants by relying on decisions of this court and so-and-so, urging that the death of a partner of a firm does not cause a suit or an appeal to abate, irrespective of fact whether the partnership is a contractual or a joint Hindu family firm. Then Purushottam and Ramkumar, and these judgments were also cited. Mr. So-and-so, but kindly skip over the next paragraph. It would thus be obvious that the controversy, my lord has very kindly got, that the controversy is confined within a very narrow compass, namely whether the death of a partner through whom the firm had instituted the suit would cause abatement of this appeal when his legal representatives had not been implemented within the prescribed period. Then, my lord, Order 30 Rule 1, my lord, is quoted. Then Order 30 Rule 4, my lord, is quoted. Then the last paragraph, our attention has also been drawn to a single bench decision of Calcutta High Court in Balkishan, which notices the conflict before the introduction of Order 30 in the Code of Civil Procedure on the question whether in a suit by a surviving partner for recovery of a partnership debt which become due during the life of a deceased partner, the representative of such deceased partner having regard to Section 45 of the Contract Act are necessary parties. Order 30 Rule 4 of CPC, however, according to this decision, contains a modification to Section 45 of the Contract Act, with the result that after the enactment of Order 30 Rule 4 in a suit brought by or against a firm carrying on business under a name other than their own, if it happens that one of the partners is dead, it is not necessary to join any representative of the deceased partner as a party to the suit. Then, Lord, kindly, Lord, comes to the last but one page.
Yes.
But the fourth line from the bottom, but starting with the words besides on the right hand side.
Penultimate page.
Well, last but one page.
Yes.
Last but one.
Yes.
With the first paragraph, last four lines. The line starting with
yes. I was looking at that.
I'm sorry.
Besides Order 30 Rule 4.
Yes. Grateful, my lord. Besides, Order 30 Rule 4 in express term applies to both type of cases where a person dies before the institution of a suit or during its pendency. This distinction thus wholly misconceived and unacceptable. The respondent's counsel has, while developing his argument, also referred to us the Supreme Court decision in Rameshwar Prasad, which lays down that the provision of so and so of the code does not override the provisions of Order 22 Rule 9 because the two deal at different stages of the appeal. Now, rest of it, my lord, is the last page.
No, here the decision of Ghakimal Hukum Chand, that was approved.
My lord, yes.
That was approved. Where is
Yes.
the decision of that?
The next,
Where it has been considered.
my lord, none of my lord, the other decisions, my lord, has relied on
Kindly come to
the last page.
no.
My lord, see the
You will
page
be
number.
finding nearing the middle 433.
433 page number देवा है।
Nearing the middle dotted lines thereafter, page 433.
My lord.
There you will be finding this seems to be correct, and indeed it is apparent that even in the earlier decision of this court,
Yes.
in Ghakimal Hukum Chand was not cited on behalf of the appellants.
Yes. That in spite of the fact that on behalf of our appellant, in the case of Radha Kishan Sohan Lal, reliance was not placed on Order 30 Rule 4 of the court, constituting the light of explanation.
So Radha Kishan was distinguished.
My lord. The bench hearing the appeal could itself have suo moto drawn the attention, but it appears that the appeal was disposed of solely on the basis of arguments. Whether the learned counsel in fact felt that the explanation to Rule 4 was not attracted to the facts founded, whether he did not notice the existence of the explanation, the fact remains that for some reason or the other, on behalf of the appellant, no attempt was made to seek assistance from Rule 1 as amended by this court and Rule 4 of Order 30 of the court. It would not be out of place to observe that the appellants were represented by the two very senior and eminent counsel, one of them so and
Now,
so.
Mr. Chaturvedi, if you kindly come to the last page.
My lord.
The ultimate conclusion of this full bench is Ghakimal Hukum Chand's observations was accepted to be the correct legal position.
Yes.
Now, if you please come to page 430 at the top left hand side, 430. Page number you will be getting on the left hand
Yes.
side.
Yes, my lord.
So now if you kindly come to the middle of that,
My lord.
in the case of Ghakimal Hukum Chand, here it has been observed.
As follows, the firm as such has no separate existence in the eye of law. It is merely an abbreviated name for the partners of which it consists, and it has no separate legal entity like that of the corporation. When a suit is brought against a firm in the name of the firm, its effect is precisely as if it has been brought in the names of all partners. An effect of using the firm's name is merely to bring all the partners before the court. The procedure as laid down in Order 30 of the Code of Civil is only adopted as a convenient mode for denoting persons constituting the firm, and a decree against the firm in its name has the same effect as a decree as against a
It
partner.
says the decree, it's on a different aspect
Yes,
also.
yes.
The decree against the firm is the decree against all the partners.
Yes. Now, what this will not considered is an objection at appellate stage in respect of a tenanted premises where the partners died. Whether Order 30 Rule 4 would come into play or not, relying on Order 30 Rule 4.
Where is that finding? Because it's this finding which has been approved in the last paragraph.
Kindly sees that the objection as regards maintainability has been turned down.
Where is the finding with regard to that? Because here, if you see only the decision of Ghakimal Hukum Chand, that decision has been said to be the correct legal position. Nothing more.
Decision.
May I?
Last paragraph.
What can question?
May I? No, may I? Kindly sees Ghakimal is also referred to at page 433.
Yes.
The last two lines.
433S.
That is a function and privilege of appeal court and subsequent court, while trying to discern the residue decidendi of that decision, may not appropriately concern itself with that aspect. Had reliance been placed on Order 30 Rule 4, read with the amended Rule 1, or had the attention of the bench been drawn even to the earlier decision for considering the question of abatement, the conclusion of this court might well be different, but that is scarcely helpful in determining the rule of law laid down and followed in that case. And the fact remains that the effect of Order 30 was not argued before the court and therefore not considered in the judgment. It may, in the circumstances, be not quite correct to say that there is any conflict between the residue decidendi of the aforesaid division benches of this court.
I think though that was an objection, but that has not been dealt with. Only is that suit against the firm is basically suit against the partners. That's the finding which has been. That
But there is no quarrel with that proposition.
So I think this full bench relates to only that. The objection was raised, as you have correctly pointed out, but no finding on that.
So next, what I cite, 1996, volume 6 Supreme Court cases, page 730. So kindly see the facts. Learning paragraph 3. Take copy the. The appellant landlord filed a suit for eviction of his tenant. So and so, a firm from a building leased out to the firm on 2 grounds. The suit was contested by the firm and written statement for the firm was signed by one of its partner. During the pendency of the suit, first respondent in this appeal, who is a son of so and so, another partner of the firm, died, filed an application under Order 1 Rule 10(2) of the court to get himself impleaded as an additional defendant in the suit. The application was dismissed by the trial court, against which the first respondent filed a revision before the district court, but the revision was dismissed. First respondent filed a second application stating it to be under Order 30 Rule 4 for getting himself impleaded. Then, however, that application was also dismissed by the trial court. He then filed a writ petition under Article 227 of the Constitution, challenging the earlier order passed by the district court, as well as a latter order passed by the trial court dismissing the second application. The writ petition was later converted into revision. During the pendency of the said revision, the suit filed by the plaintiff was decreed by the trial court, and the decree was confirmed in appeal by the district court. But the learned single judge passed the impugned order, allowing the second application of the first respondent for impleadment. Now, my lord kindly sees paragraph 7. After quoting Order 30 Rule 4, Sub Rule 1, paragraph 7. The aforesaid Rule 4.1 is clearly an exception to Section 45 of the Contract Act. The principle made out in Section 45 applies to a situation where one person has made a promise to 2 or more persons jointly. The right to claim performance of the contract arising out of such a promise would then rest with those promises together during their joint lives and after the death of any of them Such right would devolve on the representative of the deceased promises jointly with the surviving promises. Thus, if the joint promises were partners of a firm, this provision obliges the legal representative of deceased partner to join the rest in the enforcement of right to have performance of the contract. This is the nub of Section 45 of the Contract Act. But a conflict of opinions arose between different high courts regarding interpretation of the rule involved in the said section. The high courts of Madras, Bombay, and Allahabad took the view that in a suit for enforcement of said right by a firm, legal representative of deceased partner need not be implemented, whereas Calcutta High Court took the contrary view that in such a case, legal representatives were necessary parties. In fact, sub-rule 1 of Rule 4 of Order 30 has been prescribed to resolve the conflict by diluting the rigors contained in the rule embodied in Section 45 of the Contract Act in relation to a suit involving a partnership. What sub-rule 1 of Rule 4 in Order 30 of the Code provides is that it is not mandatory to join the legal representative of a deceased partner as a party in the said suit. What sub-rule 2 says, in other words, is that sub-rule 1 is not a hindrance to any legal representative of the deceased
That if
partner.
the legal representative want, they can be implemented, but that's exactly what is.
So, insofar as 1 is concerned, there is no obligation. And insofar as 2, it preserves the right of the legal representatives
to be implemented.
And that Order 30 Rule 4 is only for the purpose of the enactment, the understanding of this enactment, as I gain to learn from this decision, is to loosen the rigor of Section 47, of Section 45
of the Contract Act.
Of the Contract Act. One more decision. This is AIR 1996 Patna 70. Kindly see paragraph 1 and 2. We are laying down the facts. Title suit so and so was
for what proposition?
But same. But if no steps will not have been taken,
yes,
on the death of a partner, but there is no abatement. But I am today only addressing my lord on the issue of abatement, because as to what would not happen to the decree if one of the partners had died during the pendency of the suit. This, in my understanding, would arise only if my appeal survives, or else where do I make that argument?
Yes.
The paragraph
Patna takes into consideration 84(3) SCC.
My lord.
Yes.
Now, my lord, in so far as the judgments to be cited in support of my contentions, my lord, I rest my case here. That my appeal would abate if I was under an obligation
to substitute.
But kindly take their application for once. Not under what provision? Although our court, Honorable Supreme Court, has said that the nomenclature
is immaterial.
Let us understand what is the substance And what is the stand, my lord? What is the stand taken by the plaintiffs? The plaintiffs have always been identifying this suit to be a suit against the partners as if it has been, they have been individually, my lord, arrayed in the suit. Thereby, operation of Order 22. Thereby, the necessity of implement of the legal heirs. Default whereof abatement is by operation of law. But that is, my lord, the sum and substance of what they have, my lord, brought before my lord. I say, since the suit is one under Order 30, Rule 1, but the question of Order 22, my lord, coming into operation cannot and does not arise. If any of the rules of Order 22 has to come, then it has to be Order 22, Rule 10, whereby and whereunder, my lord, the reconstituted firm, Lord, it gets in devolution, Lord, all the rights and liabilities, Lord, in respect of the firm, the right to contest this proceeding as well. And to which I need not take any steps, default whereof is not fatal to the appeal. Lord, kindly, Lord, sees, Lord, the judgments I, Lord, indicated on the other day, Lord, cited by Mr. Bose.
Mr. Chaturvedi, how much time we will take?
Lord, I would, Lord, conclude, Lord, within another 2 minutes, if I say, only, Lord, by indicating that, Lord, those judgments, Lord, really do not, Lord, relate to the issue of abatement. And they do not, Lord, say anything more than what Order 30, Rule 4, Lord, has said. None of the judgments, Lord, if could be scrutinized, would lead to a proposition that I was under any obligation to take any steps, which I defaulted in doing. If that be so, then the appeal, my lord, cannot be said to have abated. But the application, my lord, seeking abatement should be dismissed. And, my lord, I have filed, my lord, an application, my lord, seeking, my lord, the leave of my lords, my lord, to continue with the appeal.
Continue as a firm.
Yes. Continue as a firm, because devolution, my lord, is under.
According to you, nothing beyond the farm can be looked into.
My lord.
It's only the farm which is to be looked into.
And that knowledge stands acquished.
Behind that cannot be,
my lord,
considered. That's the sum and substance of your submission in the light of Order 30, Rule 1, read with Order 30, Rule 4, Sub-Rule 1.
Yes. And they have acknowledged the reconstitution.
Yes, you said that some letter in reply which they have admitted that. Where is that? One is with regard to that contempt application you have said.
My lord.
And where is that reply letter which you have? Reply to what?
But we had, my lord, given a letter saying that your man came and inspected the premises without any notice. Trespass.
No, that letter is part of which document?
But it is
in the paper book.
In the paper book.
Page.
No, it's a part of our paper. বলছে তো বিকল্প ভুল বলছি
আমরা লিখেছি Now, my lord, kindly, my lord, come to page 258.
258.
My lord.
Yes.
But this is a letter dated 8th August 2014.
Yes.
Kindly see the reference breach.
No, 8th August 2014.
8th August 2014.
Yes.
Kindly see the reference breach of privacy and apprehension of theft of our properties. Reference. Then we place it on record as regard to the high-handed activities of Mr. So-and-so senior partner. Today around so-and-so, while we were in the honorable court engaged professor, said so-and-so entered into our premises. Now, Lord, the rest of it is not relevant. Kindly see a reply to this at page 261.
261.
My lord.
Yes.
Lord, kindly see the addressees.
Yes.
Lord, addressee number 1 is a firm. Kindly see the addressee number 2.
Yes, 2 and 3 I have seen.
This 2 is before my lord in the application. He has affirmed the application.
Yes.
He is a part, he continues to be a part of the reconstituted firm. And
no, where do you say this admission part?
They address it to me. They address it to me.
Yes, but admission as a partner, where is that?
But that is, Lord, if the word partner is to be seen, then, Lord, we need to look to the contempt application. But
yes, that you have submitted. But here, where do I find that admission as a partner? You said that they have admitted in a reply to the letter. That is what I was trying to find out.
Lord, kindly
where is
see.
the admission?
Yes.
Yes, they have addressed a letter to two persons, two individuals, the firm as well as two individuals.
Two individuals, and these are the same individuals who are in the contempt application as partners. These are the same persons who are referred to as partners in the contempt application.
Which one is earlier, this letter or the contempt application?
Letter.
Letter is the earlier.
Yeah. The letter is earlier.
Contempt application is subsequent.
My lord, kindly see is the page 269 is a contempt application thereafter.
Where do I get the date? Where do I get the date?
My lord would get 289. Kindly see page 289.
11 September 2014.
My lord.
Or subsequent to this.
So these are the same persons.
And so this letter, along with that contempt application, you say,
yes,
basically the contempt application.
My lord, in the contempt application, my lord, for my satisfaction, my lord, at the risk of repetition, I invite my lord to page 283. The categorical admission, my lord, is to be found here.
83. Yes, 2 and 3 are partners.
So, my lord, this, and kindly see, my lord, the affidavit, my lord, at page 289, my lord, it's a statement true to his knowledge. I'm sorry.
No, something came to my mind, Mr. Chaturvedi. These statements, how it is verified.
Yes.
If it is strictly applied, Mr. Chaturvedi, most of the matters.
The writ petitions will go. Well, kindly permit me to take the benefit when it is inuring benefit to me.
Anything more, Mr. Chaturvedi, you have concluded?
Only this.
Want to file any written notes with regard to this?
Well, so far these 4 judgments have, which was shown, your lordship will consider only one thing. The first judgment, the 84-3.
Mr. Bose, I have a meeting. Just
very well. 5 minutes tomorrow, 10 minutes tomorrow.
Tomorrow.
All right.
There is the division being.
नहीं हमें कोलकाता नहीं. Anytime tomorrow, my lord, 5-10 minutes before, say at 1 o'clock, if your lordship gives me.
কালকে একটার সময় কিছু আছে কালকে? So both of you want to file any written notes?
Yes, yes.
You want to file written notes?
So very well, we'll not then.
No. I'm asking. I'm not saying. I'm not shutting it off.
If your lordship is taking copious notes, your lordship had noted the judgment.
If you want, I will give you that liberty. I will give you some time. It's your choice. If you want.
We shall.
You want. When? Then, Mr. Bose, can you do one thing, both of you? So you can include your reply in the written notes. You can make your that with regard to this reply with regard to these judgments.
Just give me 10 minutes tomorrow, not 5 minutes. 5 minutes. Give me 5 minutes at 1:10.
আর কিছু নেই, একটাই রেখে দিন এটা.
1 o'clock. Just 5 minutes at 1 o'clock.
How much time it will take to file the written notes?
At least give us a week, my lord. At least give us a week.
By Monday we can file.
All right, tomorrow. আচ্ছা, ওই Mr. Chaturvedi